Not signing permission. Submitting the notes of submission that matter. The lordship's permission may make a mention. The lordship, this is the first.
Give. There is only 2 days left, sir, before the vacation.
The request for tomorrow, it was in the list.
I do not know. Let us see. Give all the. Give all the memos. Give all the memo. Yes, pass on the memos. Yes.
May I have your lordship leave to mention a matter virtually, your lordship? I mentioned last day also. I have been told that the learned AG has matters fixed on 19 June before your lordship. If on that date, your lordship, this matter can also be.
Let us see. We'll definitely see to it.
Kindly, your lordship, some precedence and indulgence.
The matter relates to regularized
Now, where you were for such a long time, we are picking up all the matters now at the verge of the closure. Well, let us see. We have directed yesterday that all this spillover matter, those could not be touched. We'll take up. So let us see.
It's an urgent matter.
Oh, every matter is urgent.
So, I'm permitted to submit what happened. This matter is relating to construction of Panchayat office, which is to be.
Whatever, sir, conserve your argument. Deliver on the day when it is listed. Give the pass on the matter. We'll definitely see, sir. We are taking all the matters. Don't worry.
This will be
Let us see. Let us see. No.
May I call the list?
Yes, definitely.
Supplemental list item number 1.
Please, my lord.
Mileage, I may be permitted to mention through VC. Mileage, on earlier occasion, I had mentioned before your lordship, Mileage were kind enough to accept.
Yes.
Mileage, may I mention?
Yes.
Item number 2.
This this is an order in the 16th C of the Act. Another group of matters will also fix to.
Oh, please give.
It's not a case of challenge of virus. It's a challenge the assessment order.
I
And
intend to
this
do
was
that.
already decided now in favor of the revenue. So far, 62 and 64.
Not decided in favor of the assessing.
But Supreme Court has already stated that it's only technical liability can be considered. So that part is not my. I due respect, but this issue was not here. So far, 62 and
So after all, it has to be heard.
Basically, to file an application.
we have already filed counter and judgment with criminal. If you lordship will need my assessment, I can situate today.
Yes.
This is the petition was kept to 24/6 for constitutional and challenge.
Yes.
So my commission may not be decided along with that.
The demand.
I intend to do it. That's what.
Filing of counter.
No. So they are entitled to amend the petition. You can't stand in the way.
No, I do not want to another payment.
Do one thing, we are granting you leave to amend, thereafter we'll pass the order. As paid for the appellate, for the writ petitioner, senior counsel, for the writ petitioner, leave is granted to file an application for amendment of the writ petition. How soon you can file?
File during the vacation.
Who I must say,
After vacation.
I am very.
Oh, sure, sir. Why you are apprehending?
No.
Item number 3.
May please both the matters. Yes, both the matters. This application was there are 2 grounds on which I am challenging this application. One is violation of principles of natural justice. 2, limitation. So far as natural justice is concerned, with effect from 20th of November 2021, I've changed my address from place A to place B.
I think you argued this matter earlier.
No, it's come for the first time. A similar matter that I argued, and my learned friend Madam Chaudhary had also argued a similar matter for change of place.
Hmm.
So notwithstanding the fact that my RC, the Lordship would kindly turn to page 184. This is the amended RC which I've, the Lordship at page 184.
Yes.
If your Lordship would kindly see serial number 9, the date of issue of the certificate is 20th of November 2021.
Yes.
And at serial number 4, your Lordship may kindly mark my address. Plot number so and so, Boichunga Tangi, Cuttack.
Yes.
In spite of the fact, my lord, that this particular address was known to them, all the same, my lords, as late as in 2025, my lords, they are issuing this particular notice in my Bhubaneswar address. The order is also passed in the Bhubaneswar address. And if your lordship would kindly turn to Annexure 2, page 117, at my lords, page 144. Annexure 2 is the impugned order, my lords, begins at page 117, the relevant portion is 144. Your lordship would appreciate its Khurda Odisha. That was my earlier place when I took my RC out of the GS in 2018. All the notices were sent in this particular address.
144.
Sorry, my lords.
144.
144. Your lordship would see.
Put the address.
Khurda address. Knowing fully well that right from Milords 2021 I have changed my address, my RC has been also amended accordingly amended.
When the show cause notice was issued.
No, the show cause notice, Milord, in Annexure 1 was issued prior to this amendment. Milord. That is why I could respond to the show cause notice. Show cause notice begins at page 29. The Lordship would turn over the page at page 30. 23rd of July.
When a show cause notice was issued, these changes have not been brought.
Is concerned, Milord. It's
Did you appear before the authority?
Show cause stage, yes, Milord, I've filed my reply, but subsequently I have not received any notice thereafter. It all went to the board. And interesting, so far as this particular aspect is concerned, the order is sent to the Bhubaneswar address. The DRC 07 demand notice is sent in the Bhubaneswar address. Your Lordship would kindly also mark that, Milord. It's not, the Lordship would kindly see page 159 and Annexure 5. It is sent to the Tangi address. It is sent to the amended address. The main order is sent to the Bhubaneswar address. The demand notice is sent by to the new address. So, Milord, the authority is very well new, Milord, that I have changed my address right from 2021. But all the same, Milord, the entire proceeding was completed by issuing notices to old address. In addition to it, Milord, so far as limitation is concerned, Milord, in this particular, as your Lordship would know, Milord, that so far as 17-18 assessment year is concerned, Milord, the date of filing of annual return was extended, and it was extended till the 7th of February 2020. As per the provisions of 74 subsection 10, Milord, an order has to be issued within 5 years from the date of filing of this return, Milord. If the Lordship permit me, I can place that provision of 7410. Lordship, GST Act. 74 subsection 10 units. Lordship Court. The proper officer shall issue the order under subsection 9 within the period of 5 years.
So it was extended till 2020.
It was extended for the 7th of February 2020. Milord. So, Milord, till 6th of February 2025, Milord, this particular order has to be issued, Milord. In this particular case, Milord, I received the order, Milord, on 13/2/2025. Milord.
Order was passed on.
Milord, order it is purportedly dated 31st of January 2025.
So that was within 5 years.
That was within 5 years, but your Lordship would kindly see. In DRC 07, I'm only given 3 pages of the order, Milord. If your Lordship would kindly see, DRC 07 begins at, the order, Milord, it is at page 159. The DRC 07 is at page 161, Milord. Lordship got, Along with that, my lord, I get only 3 pages of the order at page 163, 164, and 165. And unfortunately, if your lordship would compare this particular order, why I'm saying that this particular order is antedated, because if your lordship would, with the bare eye, my lord, if your lordship would compare with this original order, they don't tally, my lord. Your lordship would kindly say, come to page 163 for a moment.
Order is dated 4th February.
Order is date, that is the DRC 07. That's the original order.
31st January.
31st January is the order.
31st January is the order.
But the DRC 07 is dated 4th of February.
No, page
165 if you come.
159.
159, my lord, is the summary of the order.
Summary.
4th of February.
Understood.
The DRC 07, my lord, is at page 161. That is also dated 4th of February. They only give, my lord, along with this 3 pages of the order, my lord, at page 163. And if your lordship for a moment, my lord, kindly turn to page 117, the original order which was given manually to me, my lord. If your lordship would kindly compare it at Annex 1, the first page.
Now, normally, the electronic digital format it comes out. The date of uploading.
I'm making a humble submission, my lord, because this is apparent, my lord.
No, that is what we are seeing.
No, that is the 160, 117.
17, it states.
Talks about the date of the order as 31st of January.
But your lordship would
But
see.
on the top, on the left hand side top, it appears that this is served on 13th of
14th of February, my lord. And they note that urgent, if your lordship would kindly see it at the left hand side, that the superintendent adjudication to be resent to the new address, if any, by the SSA.
So by this time, they could gather that there has already been a change in the address.
And what has happened, my lord? Interestingly, so far as the speed, this was sent by Speed Port Annex 2. They posted, my lord, I've given the, my lord, the port tracking report, my lord, at page 168. So if your lord, if they purportedly passed on 31st of January 2025, my lord, your lordship could kindly turn over the page at page 169. They post this order on the 10th of February 2025. And my lord, this has on the 11th of February, it says that returned to, because it was sent in that Bhubaneswar address. So it was returned on the 13th. They ring me up, my lord. I have also mentioned in a petition the person with this mobile number who had telephoned me from the GST department. I go and physically collect the copy of the order from the GST authorities on 13th of February 2025. So my humble contention, my lord, is that this is barred by limitation.
How could it be? It simply says that issue an order. It does not say the service of the order. When it talks about the issue of the order, and the issue of the order is within that particular limitation period, then in that event, tell us that only thing is service of the order beyond the statutory period will invalidate the entire act.
Because order. Why I say so, my lord, that this particular the DRC 07 had to accompany the ordinance.
So the question is that what could be the meaning assigned to the word, the proper officer shall issue the order.
Issue the order. Issue.
Now the question is that what would be the definition? Too conservative view to be taken for the definition of a word issue, will it not frustrate? Now the question is that when the order is already there, the officer who is entrusted with the powers to pass an order, if he signs the order and passes the order within that period. Now, question of service is a ministerial act which comes in the department, it goes and it takes time. If there is any ministerial lapses, whether it will frustrate the very purpose of the act.
My humble contention, Lord, is this ministerial act is within the control of the department. At
That is the difference. Now we have to interpret not in a so conservative way that it will really render the entire things stand still.
Your Lordship would appreciate the prejudice. I get only 3 pages of the order, which are not parallel copies. If my Lord Annexure 2, my Lord, is sent to me by speed post.
You have the remedy elsewhere as well.
No, natural justice, my Lord. My Lord,
Is it coming within the purview of that?
natural justice, because they knew from 2021 that my address has been changed.
No,
At least they should give me an opportunity.
That at the time of what is the initiation of a proceeding?
But
What is the stage of the initiation of the proceeding?
so far as initiation of proceeding begins with a notice.
Correct.
And
If the notice, at the time of giving a notice,
it goes
the address was the same, no
And then-
changes was
thereafter,
brought.
thereafter
Can you say?
the statute mandates personal hearing. 3 opportunities of personal hearing as per section 75.
If somebody says that I do not want,
Because if I do not,
if he does not participate, does it
that opportunity,
make that the authorities have to just wait
No.
and then
No,
go on sending the
with-
invitation card that you come and join?
with great
Can't
respect, with great respect, if I don't receive a personal notice, hearing notice, the question of my opting for not appearing or appearing does not arise. But the entire proceeding, the entire
Have you discontinued all your business activities from that?
Yes,
What was-
that is my RC has been changed.
That is one thing,
Mother,
sir. In a common parlance,
the postal bill,
you have an ancestral house.
I do not.
Please consider.
I'm sorry.
And then you bought another good flat and you have shifted to the flat, keeping the ancestral house intact.
No, it's not.
There are certain people who are already there. Can you say that since I have already changed my address
not
in
a
the
question.
PAN, in the Aadhaar, everything, so that will be considered to be my
The
address?
question of ancestral house, Lord, this is an industrial unit at Manchester.
I
No, but
understand.
this
That is what I'm saying, that you may have set up another
No,
industrial unit and then shift. Both the units are functioning.
Had that been the case,
Have you made out a case like
Yes,
that?
Your Lordship would see the
What?
additional place of business.
Yes.
They have
What?
also mentioned in my RC my additional place of business. Your Lordship may kindly turn, my Lord, to the next page, my Lord, at page 185. The additional place of business again is Tangi and Utkal galvanizers at Cuttack. So, my Lord, my additional place of business has to be reflected. Otherwise, it will be offensive to the law, my Lord.
That's why I'm just asking.
no-
That is what is there.
No, and the postal endorsement, my Lord, not
When you appeared after the show cause notice was issued up,
No. I could not appear because
Why?
of the COVID
when it was served on an address
Not-
which is there in the RC.
Now, your Lordship would appreciate at the height of COVID in 2021, the show cause notice was sent. Right from 2021 till 2023, they kept quiet. Then, my Lord, in the interregnum, I had changed my address from Bhubaneswar to Tangi. And in spite of that, my Lord, at least one opportunity should be given to me, my Lord, in the interest of justice, my Lord. Otherwise, my Lord, this particular
Is not given there.
interest of justice, my Lord, your Lordship have always upheld, my Lord, the cause of justice, my Lord. At least my Lord, that is the least minimum I can pray before your Lordships, to grant me an opportunity of hearing.
Yesterday also I made a comment, the justice is paramount.
Justice paramount. And I just
there is no
I'm reminded
difficulty.
of
Justice is paramount,
one of
but,
our Chief Justices, Dr. Chauhan. I'm reminded of our former Chief Justice Dr. Chauhan, he says justice is the word not defined. But what would amount to injustice and justice, my lord, is left to the honorable courts. And is defined because
And
it
there
is
is
elastic.
there is a thin blurred line of
But-
distinction.
True, my lords. But your lordships, exercising powers under 226, my lords, have always upheld the cause of justice, has come down heavily when there's a violation of principle
There
of
is
natural
no
justice.
difficulty,
True,
sir.
my lord. But,
No, there cannot be any second thought on that.
but here, my lords, I have
There
demonstrated
is
to
no
your lordship.
difficulty.
I
But
have
only thing is that we were thinking that whether that is
And I have demonstrated before your lordships, my lord, that this is here's a person, an industrial unit, my lord. who
when
has
the adjudication was deferred by the
no notice, my lord.
SSC.
It began not after 2021. I have not received any notice. And 2021, my lord, I have also annexed, my lord, the various circulars of COVID restrictions also, my lord, where I could not participate. 23rd of July 2021 was the height of COVID, my lord, and it's a fact well known, my lord, to one and all. And from 2021 till 2023-24, my lord, they remained quiet. As per, my lord, as it is apparent from the order, they say that these notices were given. And how do you give these notices? It's all sent to the Bhubaneswar address, my lord. And their own RC. Your lordship would appreciate. The order goes to my Bhubaneswar address. The DRC 07 is 3 pages of the order goes to my Tangi New. So the my lord, at all relevant points of time in my humble submission, my lord, the department is aware of the fact that there has been a change of address and the unit is no more functioning in the industrial estate at Bhubaneswar, my lords. It has already shifted to Tangi, a new unit. A new place, my lords. And still, my lords, if they continue to do that, my lord, this is not. It's a fact, my lord, and it's quite apparent, my lord. And I've tried, my lord, my level best to demonstrate from the records itself, my lord, before you.
Did you go to the appellate authority?
No, my lord, I have not. Because once it, my lord, strikes at the root of it, my lord, I carry the luggage, the burden of a heavy demand which can be zero, my lord, if I produce my books of account. If I explain to the authorities. So your lordship would
That every SSC believe.
Sorry, my lord.
That every SSC believe.
And unfortunately, my lords, that is a fact, my lord, because so far as these GST and other, I should not be making a comment on that, my lords, but because that is enabling us to come to your lordship. But the amount of injustice being meted out, my lord, is, my lord, apparent from various cases which your lordships have heard till date.
For your non-appearance, you are relying on Annexure 7.
Annexure 7, my lords. I'm sorry.
For your non-appearance,
Sorry.
you are relying upon documented Annexure 7.
Annexure 7 is the order of the 15/7/2021, my lord, is the order of the, if your lordship, I'm grateful, my lord, the Special Relief Commissioner during the COVID restrictions which were there, my lord, there was a notification, an order of the government, my lord, with various restrictions, my lord. It was there in the state of Odisha, it was there pan-India, and page 170, my lord, I also annexed, my lord.
Public transport is restricted.
My lord. And safety and protection for vulnerable persons, the entire thing has been codified, my lord. And that is why, my lord, all those COVID extensions were given, my lord. The department was also aware, my lord, the finance department was also aware, my lord, that these are the restrictions for which people could not go.
Did you write to the department after that COVID restrictions were over?
No.
Because you had a copy of the show cause notice.
Because
did you communicate it to them that is there any?
No chance. I have not.
Why not?
I have not.
Why not?
I have not.
You should have.
Because this is something, my lord, this is something which is known to the entire world. My lord. I do not have to demonstrate. Not 20, with this 15, 7, 20.
Mr. Kaur, what is the normal, the behavior of a common man? If a show cause notice was issued at a relevant point of time where the pandemic struck and there was a complete disruption, then that gentleman can definitely take an advantage of that situation that if the entire pace is set at rest, then in that event, I'm not supposed to go. I can appreciate it. But the moment that normalcy was restored,
This,
and it is not a case that immediately after the normalcy was restored and the authorities proceeded in hurried manner.
3 years there.
And then that is what I'm saying.
2024.
Absolutely, I appreciate. This is what I'm saying.
No, Your Lordship.
Had it been a position that immediately after the restoration of the normalcy, the authority proceeded and decided the matter, we could have appreciated. There was a complete gap of more than 3 years.
That was because of the extension given to them by the
Complete
government
gap,
of India.
whatever.
I'm sorry.
Then when the normalcy was there, it is unexpected from a common man who has received a notice, show cause notice, that he will approach the authority or write to the authority that this is what, because of the pandemic, I cannot. Please give me an opportunity, fix a date. I will go and just explain whatever you are. You are not, you just sat. You were just waiting that limitation to over. Not to awake a person sleeping in a slumber.
No. The Stola Act and the other COVID extensions were given precisely for that.
True.
COVID
That was
COVID.
But that was lifted when?
Well, that was lifted into, I think, later part of 2022, 23.
2022.
22. And thereafter,
when it was lifted, then from 2022 till 31st of January 2025. There was a considerable period.
True, my lords, but your lordship appreciate the
what
level
is
of
expected?
literacy. The level of literacy which your lordship and the awareness which your lordships are expecting, Lord, unfortunately is missing in this particular state, if I may say so. I'm ashamed of making such a statement.
No. You are an entrepreneur.
No, I'm an entrepreneur, but
you are a businessman, and you know everything. It's not a.
No, I'm not Tata Birla where I have an entire legal team, Lord, to go into all that.
No.
I'm not that. No. Your lordship would appreciate that I'm not one of those top industrialists who have an entire legal team to look into all these affairs. Lord, here, my lord, they are 3 in 1 or 5 in 1.
They can avail the services of Mr. Kaur.
No.
Is it expected that they did not have the expert with them?
No, they come, my lord. They come
Immediately they will.
They come when they are on the ventilator, my lord. They come to me when they are on the ventilator. Had I been earlier or had I been advising them earlier, my lords, things might have been different. But they come to me in the 11th hour, my lords. And I'm making a very humble submission to your lordship. Lordship may grant me one chance to appear before the authority to explain the books of God. Because the law...
You expect an elixir to be given to come out of the ventilator?
Yes, sometimes they do. Even if it is within 7 days, my personal experience, they do. And they recoup well.
We have to go out of gate.
opportunity.
No, we are anticipating what more argument Mr. Kaur may advance before the order.
As not beyond that, not, I think I have to draw a line because I'll not be wasting your lordship's time because I'll be only repeating.
No. If we exercise such powers, then what may come?
Once matter lordship, actually this is the utilization of input tax credit and issuance of the generation of fake invoices.
That is on merit.
That's in the page number 150 lordship.
Will that come within the fold,
Regarding
Mr. Counsel?
Yes.
Will that come within the fold of 74? And particularly when you have, he has made out a case beyond the period of limitation you have passed the order.
Lordship, regarding the
Khetraj Parikh case is staring at you. Khetraj Parikh. Ramakrishna, Honorable Supreme Court has said. Delayed service of notice or delayed service of order. It is presumed to be time barred. What would be your answer? He is seeking benevolence to appear and waive out.
Thank you.
What?
The senior standing counsel wishes to help him out. Are these ingredients of 74 passed through? You have jumped to the conclusion. You have read that, yes, ITC was wrongly claimed. But wrong claim, will it come within the fold of 73 or 74? Was he aware that they were ghost dealers? It is your assessing authority has stated that he has purchased from ghost dealers. Who are ghost dealers? How could he know they are ghosts? Has he not issued registration certificates at the relevant point of time when transactions were going on? It is not one or two transactions, it was more than 29 transactions. If I am not wrong.
And immediately, so far as two things are concerned, so far as this allegation is concerned, I've reversed that in 2020. I've reversed that ITC note. I've also annexed those papers at 155. For both these two units, they said that they are ghost units. I've reversed it immediately. Way back, my lord, in 21st of January 2020, I've reversed my ITC. It's not that I've annexed the DRC 03 not to that purpose. Those two units which they claim to be ghost units.
What? What to do?
Justice should intervene.
We will record your concession that you will not insist for that limitation. You waive that right.
It cannot be.
What?
Your lordship, keep open.
You are briefing.
I'm sorry, I'm only super limitation. I'm not on actual lordship. Limitation rule 1.
You have the brief.
No, my lord has asked. My lord has asked.
No, no.
Micros,
My lord has
I don't think a
asked.
micros is proposal.
My lord has asked.
No, no, I asked.
It's all.
I think my
No, I asked.
also aware of the fact.
Oh, I asked him.
I'm sorry. I stand correct.
No, I was saying he is briefing him.
Sorry.
Mr. Arpit is briefing. You are not briefing.
Perhaps he's asking me to stop at this level.
Yes, Mr.
Rule 142.5. The lordship kindly go through.
What?
Rule 142.5. Every order is to be uploaded the DX 07. So the date of upload here is the pre-limitation period. So that is the date of issue.
Oh, I am just talking about the 74 claim.
Your Lordship, 7410.
I am just talking about 74. Suppose if we give them an opportunity and reopen the issues. Now, please, then the period of 5 years has already elapsed.
That your Lordship can under 75.
No, what disturbs us is
Then Mr. Kaur will take a plea.
he has not digitally signed. Had he digitally signed the order, the date and time would have come up. But he has put
Physical.
signature and date in his own handwriting.
Yes.
But DRC 07, he has digitally signed.
Your Lordship, the date of DRC 07 is the date of the
That
as per Rule 142.
that is Ramakrishna, yeah.
That is what is correct.
That is within
There you need not, but I was thinking, as he says, an opportunity. So I was just thinking in that line.
So you have no explanation why you have slept over for 3 years, kept quiet. After issuing notice in
Section
2021.
75(2). Your Lordship's query is Section 75(2).
What?
Your Lordship will set aside the period of limitation where the appellate authority or appellate tribunal or court concludes that the notice issued under this is under 25(1).
Once set aside, there is no
Your
limitation.
Lordship, 75(3), where any order is required to be issued in pursuance of the direction of the appellate authority or appellate tribunal or a court, such order shall be issued within 2 years from the date of communication of the direction. If we set aside the matter from this date to within 2 years, the set aside order can be passed. That limitation.
That is your interpretation, but Mr. Kaur's interpretation may be different.
Setting aside, my lord, is has a different connotation.
I know. That is what I am thinking of.
Your lordship, quashing of this order, natural grounds of natural justice, if at all, my lord, will not amount to setting aside. No. Maybe in the larger aspect, it is setting aside. But setting aside, as I have understood, my lord, the connotation is completely different.
Then if it is not setting aside, then the saving clause.
It's a quashing and a reconsideration.
And the saving clause.
I can't.
Then you will take the shelter under section 7410.
Leave it to your lordship, but
That is what troubles me particularly.
may I just humbly make
That troubles me that
may I
today
just
if
humbly
we
make a submission, subject to what calls, your lordship may grant me a chance. Leave the question of limitation open, for the authorities to consider. If at all they agree with me, fine. Otherwise, they'll go ahead with the merits of the case.
No, we will shut the door of a limitation of 5 years.
Oblige.
On your waiver.
Your lordship need not consider. Need not.
No, it has to be on your waiver. Waiving your right. To take that.
Definitely, Lord, I definitely cling to that straw, mills. I have no other resort.
What?
Well, drowning man, Lord, the last resort to cling to whatever comes his way. So if this comes to in my way, Lord, in my favor, Lord, I definitely accept the lordship's suggestion. Please kindly give me a chance. I'll not raise the question of limitation. I'll try to establish my case on merits from my books of accounts.
Yes. Think about it.
So, you have instructions in this? You have instructions? Why notices was sent to for the address and the DRC 07 was sent to this new address?
Yes, I need it.
You don't have instructions.
Let them take instruction. Take instructions and come back. We will decide because we have to reasons that why you have not followed this and why ultimately at the time of the demand notice, you say that services to be affected at the changed address.
They
You
have
have to
noted,
show.
and at page 170, they've noted that.
No, I have seen. That is what on the left hand side top they say urgent and then say at the next address. That I have noticed. So you have to show your bona fide. How soon? How soon? How soon you can get your instruction?
After vacation.
After vacation? Why? The authorities are not in vacation. I think the department is open. Yes.
After vacation.
Whatever after vacation. Permit them to move before the vacation goes. Taken instructions and we are directing this matter to be listed on the very first day of the vacation.
Yes.
Some interpretation.
What? You have been served long back.
No, let him take the instructions. It will come within vacation.
First day, immediately. The next week. First day of vacation.
So one line shows your lordship.
Oh, one line, nothing.
One line, Lord,
Oh, nothing.
because your lordship so would appreciate not my not or your lordship is don't instruct my learned friend to instruct the department accordingly. That this matter is coming up after
That he is taking instructions.
The seminal point involved in the instant writ petition is whether the impugned order in original dated 31st January 2025 is an outcome of the violation of the principle of natural justice. In the sense that despite having made aware of the change of address, all communications subsequent to the show cause notice was alleged to have been made at the previous address. Stop. An ancillary point is also taken. No.
Bhubaneswar it is.
No, that was the Bhubaneswar. An ancillary point is taken by the petitioner that the authorities passed the said order in original dated 31st January 2025. But in fact, it was sent for communication on 10th February 2025, which is beyond the period of limitation provided under section 74 within bracket 10 of the GST Act. And therefore, such order is per se a nullity for the reason the authority lacks jurisdiction on the day of its issuance. That is beyond 5 years. The Mr. Mishra, the learned,
Mr. Sahu.
Mr. Sahu, the learned, what, junior standing counsel or senior?
Junior.
Junior standing counsel, pays for an accommodation to take appropriate instruction from the department. Considering the urgency and not considering the point so agitated in the instant writ petition, and the fact that the demand order has already been served upon the petitioner, which is likely to be implemented, causing a serious prejudice to the writ petitioner, we feel that the matter may be listed before the first day of the sitting of this court during vacation. On the first sitting of this court during the vacation. When Mr. Sahu would disclose the instructions taken from the department, it is open to the petitioner to plead for interim protection before the bench on the next date. However, what in the event the point raised in the instant writ petition is decided in favor of the petitioner, it would invite as a result effect, the demand has to be set at rest. But pending such adjudication, if any coercive steps are taken, that would also cause prejudice to the petitioner. We therefore direct the authorities not to take any steps in the meantime till the next date of listing.
Put the date of the objects intended.
Sir, I believe till now the dates have not been notified.
Okay, I'm sorry. I'm sorry.
So
The
that's
first
why
Truman.
I have kept it in this way. First day of the sitting.
Much obliged. Much obliged. I'm grateful, madam.
Item number 4.
May please, my lord. My lord, this item 4 pertains to cancellation of registration certificate under GST Act.
Item number 5.
My lord, this item pertains to in essence of the GST tribunal. That
10%. So is the other side. So Michelle, you are appearing.
Item number 6.
Assessment. Article 73 is impugned on the 2 grounds. That non-compliance with natural justice and the order is barred by law of limitation.
Order is barred by
Long limit. Because so 73.
If I have a preliminary objection, your lordship may kindly consider. This read petition is not maintainable since the order is of 2023 and the read has been filed in 2025. It is against the set law. Your lordship has decided the case and also Honorable Supreme Court judgment and also the coordinate bench judgment and also Honorable Rajasthan High Court judgment.
what?
So far as the maintainability of the read petition,
Maintainability or entertainability?
entertainability.
The recent judgment, have you heard, have you seen?
Your lordship and
2025 volume 3 SCC of this. Now I can say the erstwhile Chief Justice of India delivered a judgment, 3 judgment. Justice Sanjeev Khanna.
Your lordship, 2024 judgment
Have you seen very recent judgment which is reported now,
23.
where it says that you can't put a, hey,
here.
bring the book on my table, the first one.
Godrej sir,
Very recently, every judgments have been the Shyam Kumar's judgment and every.
No, here, let's see, so far as the delay is concerned.
It says that you can't put any fetter in an exercise of Article 226 power.
Your lordship, I'm well concerned.
You can't.
In these particular batch of cases, in particular, Honorable Supreme Court, as well,
If I am not wrong, it's a Prabha Jain or something.
Your lordship, what is the issue?
you have referred to this. My lord has
Passed.
I've made it very clear.
Your lordship.
It has made it very clear. It is self-restraint.
Your lordship,
So
but the issue is same. Here,
Oh, that is a different, again, I am saying, it says it's a self-restraint. That is what the Supreme Court has also said in those judgments.
Your lordship, the Supreme Court judgment, what I have given, the Glaxo, why in these batch of cases, your lordship, Honorable Supreme Court, Honorable Coordinate Bench, Honorable Rajasthan High Court, what has said, where there is a upper limit, when there is an upper limit of condonable of delay by the statutory authority. So what is the issue? What you cannot get directly, you want to get it indirectly. So that is the issue here. So far as the maintainability, entertainability on particular issue. So Honorable
My brother, in one of the judgment with the erstwhile Chief Justice has decided it.
Your lordship may kindly look into the Honorable Supreme Court's order in Glaxo. What Honorable Supreme Court has said. Because there is an upper limit.
I'm giving you 3 judgments.
Your lordship. Whether I am not on 226 delay. 226 delay when there is the upper limit in the statute. And at the time of passing this order also, your lordship, was that judgment was there. Honorable Supreme Court judgment. And your lordship,
No, this has come very recently.
oh, I'm not on to it.
Tamil Nadu, this is the Tamil Nadu Cements Corporation of Corporation Limited. What says the micro, small and enterprises?
Yeah.
This is 2025 volume 4 HCC page 1.
Your lordship. Your lordship,
Is a 3-judge bench. The Supreme Court, where the erstwhile Chief Justice of India has held
your lordship.
on a scope of 226.
Your lordship, this judgment.
I think paragraph 53 onwards.
Your Lordship, I'll go definitely go through that judgment.
The issue therefore which arises and needs consideration is whether there should be an absolute and complete bar to invoke the writ jurisdiction under Article 226 of the Constitution, even in exceptional and rare cases where the fairness, equity and justice may warrant the exercise of the writ jurisdiction. The access to High Court by way of a writ jurisdiction under Article 226 is a constitutional right, but also a part of the basic structure. It is available to every citizen wherever there is a violation of any constitutional right or even a statutory right. This is an inalienable right, and the rule of availability of the alternative remedy is not an omnibus rule of exclusion of the jurisdiction, but a principle applied by the High Court as a form of a judicial restraint, which is what I also said, self-restraint, and refrain in exercising the jurisdiction. The power to issue prerogative writs under Article 226 is a plenary in nature, and the same is not limited by any provision of the Constitution and cannot be restricted or circumscribed by a statute of.
Let's see what happened. Since there is an upper limit, what Honorable Supreme Court has said in the case of GlaxoSmithKline, your Lordship, the judgment has.
And he considered all the judgments reviewed.
Your Lordship, only I don't want. I have no authority to.
No, cannot be.
It is
Not a priest. Cannot.
So that the only thing is that the statutory offer cannot be filed when there is a upper limit. Your Lordship, that issue is also your Lordship's view is different, but
My brother's view is also there.
Your Lordship, what that is pending before Honorable Supreme Court and stays there. So now my respectful submission, this Glaxo judgment of Honorable Supreme Court, what Honorable Supreme Court has said, because there is a statutory restriction.
a very nicely placed. Para 59 of that judgment. The principle that the High Court should not issue a prerogative writ when an alternative remedy is available may not apply when the remedy under the statutes is onerous and burdensome in character, such as when the party has to deposit the whole amount of tax before filing an appeal. An alternative remedy must be equally efficacious and adequate.
There is 100% deposit. So for that it is burdensome. Here 10% deposit. So that your Lordship, for a moment that Glaxo judgment for a moment.
Once ex parte order. Is it not burdensome? He is not allowed deductions or exemptions which he has claimed.
Here.
In one of the cases I have brought out, again followed Kiran Stone recently. In 2010, this court in division bench said the assessing, it is even expert, yes, it is bound in duty of the assessing authority to grant deductions even if it is not claimed. This court followed one of the Supreme Court judgments. So simply seeing most dealers, non-existent dealers, simply rejecting them without verifying their registration certificates, the position on the date of transaction.
What to do?
Yes.
Don't take a preliminary objection. Not sustainable. Let us hear him on merit.
Then everything, your Lordship, just imagine for a moment. Then your Lordship, in all statutory appeals, after 3 years, even the delay in filing an appeal, they will come to High Court. Without
No, Mr. Mishra,
and then
you have not understood the pulse. You have not understood the pulse of the bench. No, you have not. When you started taking a preliminary objection, then the preliminary objection must be sustainable on a strong legal parameters.
Right.
And when there is some kind of a relaxability or a laxity which is already there in
Yeah.
exercise of power by the court,
Well,
then in that event, you can't say that the court should refuse to exercise the power. It all depends upon the facts of a case, whether the court will exercise or will not exercise.
well,
So you can't say in absolute terms that in such situation, nothing. Let us see that, hear him.
for a
There,
moment,
let us hear him.
For a moment, page 5, paragraph 10. If under this averment, the read will be entertainable, then your
Again
lordship,
is a question of fact.
paragraph 10, for a moment.
That means the
No,
fact.
maintainability.
No,
I'm asking-
fact. That means you are arguing on fact.
No. The drafting, the pleadings, your lordship may kindly, under this averment,
Then
the
we'll have-
read is maintainable.
Then we will after hearing him we can consider it, but not as a preliminary objection.
This paragraph 10 is my preliminary objection.
What?
If under this pleading,
Yes,
a read it can be entertained.
yes. There may be other paragraphs which may invite. Where is the difficulty?
Yeah.
Don't put a preliminary objection of such nature.
I'm sorry.
No.
And it's just 2 minus. It
Yes.
is section 72, 73, order was
Yes.
Minister 2 series,
Yeah.
page 12.
Yes.
Order was passed under section 73
Yes.
for assessment period for financial year 2017-18, tax period from July 17 to March 2018.
Correct.
And the due date of return is from 7th February 2020.
Correct.
So as per 7310, the order is to be passed within 3 years, my lord. And notice was issued on 21/9/2023, and the order was passed to 31st/12/2023.
31st.
12/2023. After the date, my lord, invitation.
Yes.
And I saw the notice, person to a glance, that on which day it was uploaded is not been mentioned. Page 17.
That has been extended.
No, just come to page 16.
My
Tax period,
17.
everything.
Mal.
Come to next page. First sentence, please. Please explain. They are not marked. Please explain. Huh?
My lord has seen, my lord honorable Chief has seen in another case also the same thing.
So please explain.
That is copy paste. Your lordship knows.
Copy, paste.
Non-application of right.
Yeah, only the tax period. The DRC 07, the DRC 07 as well as everything is right, only that period in the annexure, summary of order annexure.
What was the last date of extension?
7th February 2020.
Was it extended subsequently?
Yeah, Lord.
And
that has been extended under section 168A. So far as
Till-
by recognizing that COVID period
till
till 31st/12/2023.
20?
Notification number 9
Those are challenged here.
No, 56 has been challenged. 9 has been.
So it was within the period of limitation.
Within the period and actually
The due date was 7th February 2020. So far as financial year 17-18, the due date was 7th.
But that's why he says that it was extended subsequently because it falls within that particular
I'm sorry.
the purview of the pandemic.
In all those notifications that my learned friend Mr. Mishra is referring,
No, I'm
due
referring
date-
only one.
the due
Nine
date for
has
filing
not
of
been
returns has not been extended. That is the preliminary objection which we took in those cases. That without extending the date of filing of returns, you have only extended the date of adjudication.
Okay.
Filing
Here,
of
below, the filing of returns has not been extended to 1718 beyond 7th of February 2020.
168
So one-
only covers statutory authority's power
Now,
to adjudicate.
the adjudicate, not to extend this particular term.
return date we have not extended. Return date
Yes.
we have extended
Then I
in
will-
2020.
Yes, 7th of February 2020 was the last extension of 1718 for returns.
Pandemic was in peak.
Because no,
After pandemic, so due
22,
to pandemic.
no,
once-
the pandemic started sometimes in the month of March 2020.
2020.
So it was pre-pandemic stage. You can't say that. So they will definitely not extend the period of filing the return because, but the adjudication, if they have extended the period, then in that event, where is the difficulty? If the adjudication is done within that period.
No, please, Mr. Mishra, please get that date when you have put in place the returns. 3B returns was,
3B.
did not come within
That is
your
2A,
time frame.
2A, yellow. 3B. 3B was initially there.
Okay,
2A.
When
There was
when have you brought it?
prior to 2020, prior to 2018, I think.
It's only for issuance of order.
2018.
18th
That
of
extension was only for issuance of order, not for filing of returns.
Yes,
No, filing of return is something, that's, I understand.
Mr. Karan, what I am asking is 2A, initial stage it was not there.
Madam,
It has come later on.
madam,
So when has it come?
2021 it has come to me, not early.
By
Somewhere very, very late, it came very late after some amendments.
all the periods, 17, 18, 18, 19, 19, 20, the limitation period, so far the passing of the order
Oh, I understand.
has been extended.
I have already said that there is a gulf of difference between an extension of time to submit the return or filing of the return and the extension of time for completion of an adjudicatory process. That is a different one.
So 168,
Consequently belongs to 7310.
That says 3 years.
My lord, from the due date of return.
Absolutely, sir. If that period is extended subsequently, then what?
Due date is literally, my lord.
And the problem is because of the suo motu writ proceedings of the Supreme Court, which says that limitation where there is provided, it will come to an end.
only that benefit petition
So
of
that is why 168A was introduced by way of
My lord.
So
postmate.
ordinance, thereafter statute.
But my lord, if 7310 taken into consideration, the due date, as per the language, the due date is 7th February 2020. So 3 years means, my lord, the limitation ends.
but this limitation was set at rest till the March
My lord,
2023.
Since my assumption is that since the due date is prior to pandemic, so notification is no application. My lord.
No. See, adjudication falls within.
That's
What are you talking? Look at the judgment, the first order of Justice Bobde, as his lordship then was. It says that in any matters where it falls within that pandemic, stop,
Shagufa, I think. Shagufa and that.
stop, cannot. I have delivered a judgment where the limitation ends before the pandemic struck. Whether the advantage can be taken. I say no, can't take advantage.
My lord, my other point is that no notice was served to me. And my lord, in answer to the DRC 07, they have not mentioned that on which date notice was served to me. Lordship, only they mentioned that regarding notice was sent, or which date was served, they not mentioned. Simply they mentioned DRC 07, the date 21/9. And the financial lordship mark that assessment financial 2017, but in nature it's 2021.
Yes.
In the web portal, it was uploaded.
Because if it's section 169, first is to first under the personal.
My lord
I
has
have
already
already taken a view that there are various modes.
Yes,
If any of the mode is exhausted, then
my lord.
it's not necessary that every mode is to be exhausted.
But my lord, the annexure to DRC 07 is silent on which date it was uploaded in the portal, my lord.
All right.
That is on 21st/9, page 17.
It is already there.
Able to 3 notices have been served.
But my lord, the lordship rightly pointed out that the financial year, my lord.
Oh, that is a cut and paste that we said that that's
No,
a.
you come to conclusion. Look at the
Yes,
preface.
yes, it is right. You're
Ah.
right.
So conclusion he has made correct.
My only
I
prayer
have
is
gone
that
to.
I should be given opportunity to file my reply, my lord.
What?
And more of
How many opportunities everybody will get it?
at least
If you receive a notice and chose not to appear, you had an opportunity, did not avail the opportunity. Every time the court will give you.
my lord, while my another point is that I have not been extended to benefit of 120, though order was passed was on 73, that is waiver of tax and penalty, but that has not been done, my lord.
So you go before the appellate court.
But in
But limitation has now come. What to do? Before the
accordance with the law, my lord.
Your Lordship, liberty may not be granted. Your Lordship, his statutory right, he can file appeal. But Your Lordship may not, because it may be misunderstood here.
What do you think?
Mr. Counsel, it appears you have not discharged your liability. Your admitted tax liability.
My lord.
It's nothing. Okay. If you would delete it, what is available under the law, you cannot delete before the appellate. Yes. Go before the appellate forum.
My deliberation of the concern according to the law, my lord.
In accordance with law,
My lord.
if available to you.
I'm already at 6. So,
It is to be considered. My lord.
Yes.
Item 7.
Alternative remedy, assessment order.
What is this?
Cancellation of listing.
Cancellation. Who is appearing? Yes.
Item number 8.
May I please? Look, this is a matter where your lordships were kind enough, my lords, to hear me at some length.
Yes.
And Lord, the respectful submission is this, that though your lordships, lords, did hear me, the question is that for the period that I was in court, this is not, my lords, a case where tax is being avoided. Tax has been paid, tax has been settled. There is no dispute about the incidence of taxation per se. None at all. The dispute is one, my lords, when this court sets aside a previous order which did not have any meaning, then in the face of that order, for the time that has been spent in court, whether you can charge interest on that amount which has been nullified. And your lordships heard me, my lord, and then asked the other side, while I am still to complete, that what are your instructions on tax? They filed a counter which we have received late last night. But we'll deal with that in the rejoinder. But I have filed an affidavit which says, my lords, that 22 crore rupees, 21 or 22 crore rupees, paragraph 6, 7 and 8 of the affidavit that has been filed, my lord, on 8th of May on oath states that there are 20 crores 74 lakhs 53,126 rupees that are liable to be paid as refund. So, my lords, if this amount is to be paid as refund, then this covers the entire sums that are before your lordships in issue, whichever way your lordships will decide. Because I have not pleaded some restitution principles on 144. So lordships may consider this. It will be a privilege, my lords, to appear before your lordships on physical, because this matter was argued physically. Now that the counter has been received late last night, we'll, my lords, give it our rejoinder, because there are certainly inaccuracies therein. But for the equity balance and the balance of conveniences, this affidavit clearly brings out that about 21 crore
that
rupees.
this amount is still lying with you. As
Yes, my lord, it's with them, my lord. So let them not take any coercive action. The amount is with them. This is actually my money which they have to refund.
And what is the demanded amount?
Lord, 22 is the demanded amount, and
tax. Sorry, levy of interest, my lord. The two order was passed by the IBS, my lord, on 31st July 2017, and another order was passed in 31st May 2021. So that is the main dispute in this matter. The challenge that the interest, they are not entitled to pay the interest up to 31st May 2021, my lord. My lord, may I draw the attention of the school?
Now he wanted to say that so far as a demanded amount is concerned, since these are the amounts which are lying with you, which are an excess payment, which they are liable to be refunded, or it may be adjusted in the event the demand sustained. So at least the interest of the revenue is protected to some extent. What he really wanted to say, and then say that since he has received the counter last night, and this counter contains certain averments which need to be dealt with by way of a rejoinder to be filed. So he's seeking an opportunity to file a rejoinder to the counter.
Yes.
And then says that by way of an interim measures, since the substantial amount is already lying with you, which either may be either refunded or to be adjusted. So the protection is already given you. The revenues protection is always given. So don't take further coercive steps.
That's all.
What you wanted.
That's all.
My lord, verify the money line.
No, that is, he has shown the additional affidavit in paragraph 7. He has shown the deposits to the tune of 20 crores 74 lakhs. This is what he wanted to highlight. If you see,
the physical copy of the counter and the last page, all the amount has been adjusted. It will be showing that, and balance 22 crores are lying as on today.
still due and payable by them.
Yes.
After adjustment of this,
We have already adjusted as per our
This is the last page of the contract.
If any amounts, let's see, it's due, let me verify again then.
This order has been passed on 11th of April. This order has been passed on 11th of April, in lieu of which the refund has to be given to us.
There's an adjustment of this 20 crores. Does not appear from the last page.
My lord, the outstanding demand as on date, my lord.
Well, that is why he wanted to file a rejoinder saying that this amount is disputed. And then says that there is already a substantial amount which is already lying with the revenue. And if you say outstanding means.
Item 41 and
This amount anywhere.
on behalf of AAC.
The demand would have been
45 and
46 crores. If you say outstanding as on day is 22 crores, that means the demand must be 42 crores. And after adjustment of 20 crores, 22 will come. Where is the figure of 22? Or 20?
Annual lawsuit regarding this, the amount which has been paid on different dates, 20 crore 74 lakhs some odd in page number 5 of the additional affidavit.
Where?
You have page number 5 of
Yes,
additional-
I'm on paragraph 7.
Yeah, lawsuit. We
And
have
those is spanning over for the year 2022, 2023.
Yeah, lawsuit. This we have now we have to verify that this probable this amount may be adjusted in this.
But that is
Because
not
the
reflected in
department has given the latest figure to us that outstanding demand is this much, 22 crores.
My lord, your lordships could have it on the 30th of June, by which time my rejoinder will come. Nothing is going to change. They are fully protected. And this amount of 20 crore 74 is the principal amount which will carry interest. So assume, my lords, that they optimistically win. They will be, it will carry interest on this amount also. So department is completely protected. I think this statement should come from my learned friend himself that yes, we'll not take any coercive measures till the next date. Your lordships decides it one way or the other. Your lordships have heard the matter.
So this money is already there. It is during the pendency of an appeal they are paid.
Mr. Pedia, you file Harassment. We read the sentence. In the meanwhile, and during the pendency of the above appeal, the petitioner made the following payments against the demand dated 36/2021, which we are concerned with, right? So around 20 crores and all he has discharged. Whereas you show from your demonstration at last page, right from 9/10 till 15/16, is 22 crores. So
substantial amount has already been secured.
So what more you want? So counter you have filed yesterday only. And it is not come on board also, on our board.
Let us verify this amount. If this amount has been adjusted in our list, then he'll pay that amount. We'll inform him.
We are saying, don't take coercive measure.
We'll inform him. We'll inform him that it has been adjusted. Then he'll have to pay.
Then there will be a demand of only 2 crores and odd.
No,
Only
what
2
I want to
crores,
say.
2 crores and odd.
No.
Nothing more than that.
I want to say that if this 20 crores had been adjusted in our list, which I am supplying, and balance 22 is left out, he will verify. If this 20 crore is there, then stay will be there. We won't have any problem.
He is saying that we have already challenged your competence and the authority to impose those.
And there are two aspects in the adversarial system adjudication. Either the court will accept their version and then quash whatever the proceedings you have initiated against it, or the court may reject their contentions and uphold whatever is there. These are two possibilities. What he's saying is that in either of the possibilities, if he succeeds, then at least he is liable to get this amount refunded. If he loses, then at least the interest of the revenue is also protected. They can adjust this particular amount which is already lying, and the remaining amount, whatever that can be demanded. So in both ways, he wants to say the equity demands that the revenue's interest is protected. Now, question is, you say that when this chart was prepared, whether the chart took into account this particular amount which they have already paid, but none of the clauses, this one shows this figure.
In this our chart, your lordship, a year-wise adjustment has been made and the date of payment. And in the additional affidavit, he has mentioned the date. And it is year.
But there is nothing which has come out in this. Because if you say as per the SSC, please come, then I'm saying, as per the SSC, these are the amount which is paid, 376. This is the amount, come to the chart. The box, small box. What is this figure?
Total TDS.
What is this figure?
37.
This is small. Yes, 37.
Yeah, lordship, this is the amount of interest which we have calculated. We calculated
the payment of the TDS that comes where in this TDS or advance tax. What is the figure which you have taken? And for which year? Have you seen? Up to 2015-16.
This payment has been made up to till today.
That you have not, because they have said in their affidavit that this is the figure 26 years of the assessment year 2018-19 will reflect that this amount. That shows that this entire amount is shown during that particular assessment year, which I do not find any reflection here. Up to 2015-16, you have taken the TDS.
Mr. Bhatia, when
What are you talking?
demand which is before us is relatable to 2017 to 2024. Why have you computed from 9-10 to 15-16?
This is the for the assessment which the challenge in the settlement commission. This is the chart of that only also. IBS scheme.
Let them get
IBS scheme is up to 15-16.
You come to where? The demand relates to 17 to 24.
Yeah, that we have to verify. What I want to say, the amount which he is reflecting that has been paid, I have to verify if it has been adjusted in this chart. Then we'll inform him and he'll pay the amount. Otherwise, your lordship, we can grant the stay if.
When you prepared the counter, have you not verified this as well?
Definitely, this has been adjusted always. I have to again verify.
Where? And this affidavit was available to you when you prepare a counter.
But the last order of the settlement commission was passed on 31st May 2024. So the dispute in between from the assessment year 2019 to 2015-16. The first order of settlement commission was passed on 31st July 2017.
Sir, when you put in the counter, was this affidavit dated 8/5/2025 was not with you?
Was with them.
And were the figures which is reflected at this paragraph 7 was not with you? Was it not incumbent upon you while preparing the counter to verify?
I will take the further specified.
If you want to say that whether those payments have been made or not made, Annexure 4 to the affidavit is very clear. That's page 24. There's a downloaded copy of the form 26AS reflecting the entire amount which they have paid. This is your document. Will you not verify that? What more verification you want? The question is the adjustment. It's not expected, sir. When you file a counter at the letter A time, and then you will not include those. Don't make out a case at the bar. Try to make out a case what your authority has said. Don't improve upon.
Then why, when the order was there, why at such a late, I would say the stage you just give them a count? But you have given him 1 week before you knew it that the matter would be listed. And this matter continued just from yesterday. And you give it yesterday night. That really delays. It says 13.5. Yesterday you are 5. Had the matter been taken up yesterday there?
We have already.
In the morning? Where?
When I was giving the counter, told that after the matter will be taken up, we give the counter in the court itself. We have filed that, I will file online.
We are fixing this matter immediately after the vacation.
No. Additional affidavit dated. We make it already 55. This. Para 7 that during the dependency of appeal before the income tax authorities against the demand dated 36/2021 around 20 crores and odd has been deposited, which is reflected on 26 AS as uploaded to the income tax department portal. Referring to counter affidavit filed by the income tax department yesterday, he submitted that at annexer C/2, it is shown that right from 2019 to 2015-16, the outstanding demand as on date is around 22 crores and all. He submitted that since substantial amount has been paid against the demand, the petitioner deserves to be protected from taken coercive measures since counter affidavit has been served on him late in the evening yesterday only. He seeks permission to produce and file his earner affidavit even next month, since the
documents as referred to above and relied on by the senior counsel. The weeks that substantial amount has been deposited as it is the map. In the next bit of listing, the opposite parties are restrained from taking an adverse action to enforce the yes, still matter.
25th June.
25th
June.
June.
Lord, could your lordships be kind enough, 30th of June, my lord?
Small day.
30th, sir, I may not be in the country.
30th June.
Lordships, so obliged, deeply obliged and grateful.
Yes.
Item number 9.
May I please be next? Petitioner Lord is a cooperative society and a 147 order was passed. Against that 147 order under the Income Tax Act, petitioner preferred an appeal. And during
Appellate court set aside the order.
sorry, Appellate court has set aside. What has happened in the interregnum orders? While my appeal was pending, an attachment order was issued by the assessing authority.
Now, after the appellate court set aside, then what will happen to the attachment?
So my claim was for the refund because this is a cooperative society. In one account, 53 naya paisa was left. In another, Lord, some 47.
Certain cash amount you deposited, which was considered to be the income.
Lord, ignoring my claim of ATP, which was rightly, Lord, taken note of by the principal commissioner, who granted me full stake.
What you are challenging?
Lord, I am challenging, the Lord, since this is a cooperative society, now there's no order which is staring at me, no demand, Lord. So this amount which has been taken by him, it should be refunded to me so that I'll be able to run my affairs. And only 53 naya paisa is pending, Lord. And you have a lot to appreciate.
That's a open and shut case. What? The attachment was passed on the basis of a order of the assessing officer, which was set aside by the appellate authority. Then you will have to refund the amount.
Lordship, in this case, the attachment was made prior to passing of the order. Of
Whatever these attachment, the demand goes, then what remains?
Matter has been set aside, your Lordship. Matter has been set aside.
So what set aside means the demand, the order assessing the taxable income that goes. So there is no taxable income, no tax is paid. Why you will take our money?
Let him file an application before the department.
I have already filed. That has been rejected. That is the
Where is the order?
The order, Lord, is Annexion 9, Lord, at page 71. I've done that job, Lord, page 71, Annexion 9. That has been rejected with authorities. I tell him specifically that the principal CIT has stayed this amount and are directed you to refund directed to.
How can he say that it was they taken when the stay application was pending and then?
On 1st of January, my lord, I filed a state petition.
I have.
Third, my lord, he disposes of
on a very basic fundamental principles I am asking. Suppose a demand is raised and that on the basis thereof the money is recovered. And ultimately it was held that the demand is illegal. Then will you keep the money with you? Or you are supposed to refund the money?
You know, since order was passed, CIT appeal order was passed on 20.
PB letter, sir, I understand. I am just talking about when you took the money, you took the money on the basis of what? The assessment order?
Yeah, Lordship.
Correct?
Lordship.
The assessment order is set aside.
No, this order was passed prior to CIT appeal order, Lordship. The CIT order is passed on 20.
I am on a very fundamental principle, sir. Show me the law that it will not. Is a question of restitution.
The law says that if the matter has been set aside, it should be refunded. So, but our order has been passed after before
Will you
CIT
not, will you not refund?
that amount was taken 20 as per the law. When the demand is there, 20% amount.
What is that? We'll have to go into very basic question. What you treat a thing as law? What do you think? What do you treat the thing as law?
You want to say this, that the order of attachment was in January 2025?
No, attachment was in December 24.
Yes.
And he filed
What he has
this
not-
petition on January.
This rejection was on 22/1/2025. The order in appeal was passed on
24/2/2025. No, Lord, I want to say that.
Oh, that you want to say the further application. Make a further application. That is correct.
Already made to the principal commissioner.
Where?
Not here, Lordship would appreciate not the next direction.
Sir, you wanted a refund
My lord.
at a stage when the order was staring at your face.
Not that your Lordship would appreciate there was a complete stay by the principal commissioner.
Whatever,
And that
whatever, we can't find
Then
fault in
appreciate
it.
your Lordship
If
would
the
appreciate-
stay came later on,
No, the stay has come later on, but your Lordship would appreciate the
no.
conduct. My stay application was pending.
you go get there and
And then-
make an application.
Lordship, I made an application, sir.
Where is
That
the
will not-
application?
After
After that, no, the principal.
Where is that?
Commissioner.
After 24/2, where is the application?
Your Lordship would see the
Show us application after 24/2.
the principal.
I do not find.
The principal chief commissioner at page 75.
Please, I do not find.
No, page 75.
That is 5/2. That is 5/2 prior to 24/2.
Lord, he's not at all listening, my lord.
So what? You go and make an application or
I've already made, my lord, page 75. my lord.
go and make an application. Can't.
After finalization of appeal,
My lord.
what Mr. Khidr.
So motor, they should have refunded it, my lord. My application is not at all necessary. While my stay is pending, they will not attach it on 3rd. Then they dispose of my stay application on the 6th. Your Lordship may kindly see that.
Yes, correct. Refund has to be made.
Milord, first, Milord, I file a stay petition. 3rd, he appropriates the amount, Milord. 6th, Milord, he rejects my stay petition. Your Lordship may kindly see the conduct. And 20%, Milord, he is ignorant of the fact that the Honorable Supreme Court has said in LG Electronics case that this will not act as a fetter to the statutory authorities, Milord. Your Lordship may kindly, Milord. And this, Milord, and ATP, Milord, he says that ATP deduction is allowable to me. I'm a registered cooperative
So
society.
you succeeded before the appellate forum
True, my lord.
on the merit.
And Milord,
Now the question is refund.
Milord, so
Now it appears that your application was rejected earlier when the appeal was pending. The order was not set aside.
thereafter, Milord,
And thereafter, nothing has come out from after 24/2/2025.
Lordship, see, kindly see
So
the
in
conduct.
that event, if they want to refund, you just
But
approach,
Lordship,
we are permitting you to approach.
At page 75, my application before the principal chief commissioner is also pending. He's not.
Where is a pending application?
Page 75, Milord, page 75.
So these were the application prior to it. Then you will have to make certain facts
Your Lordship would appreciate.
to his knowledge. At that point of time, you have not stated that the order of assessment has been paused and set aside. You have not stated.
Your Lordship would kindly see.
So make an application.
Your Lordship would kindly give
Make an application. That's all.
an application, Lordship would direct, Lord.
No,
And your Lordship
we
would kindly see the conduct, Lord. So, but
We
first,
understand for what reason you are so vociferous.
first, Milord,
I understand why you are so vocal in this.
so this is Milord,
Because of the interest. I know.
and Milord 53.
Because of the interest. Make an application.
Your Lordship may make it time bound, Milord. Otherwise, this will continue, Milord.
No.
I'll make an application tomorrow. Let him consider, Milord, within a week time. Because your Lordship knows that they know the law.
Order of the CIT appeals to the higher tribunal. You have not. So you have accepted it. Refund the amount. We are directing you to refund within 4 weeks.
Let me file an application.
Not necessary. application. Under what provisions?
Is there, after finalization in appeal, is there provision that he should make an application? While taking, you don't require application. While refunding, you want.
What's the matter has been set aside?
So what?
Is that assessment?
So what?
This assessment.
What is the effect? What is the consequence of set aside?
We cannot.
What is the consequence of set aside? You will hold the money. Article 265. Article 265 permits you.
After
Mr. Failure. 265 permits you to hold that money.
That they file an appeal effect they file an application for an appeal effect, then according the refund would have been flowed and it have been given.
Why? Where is the provision?
Appeal effect is so motive.
Where is the provision that an application is to be made? I do not find that for refund application is to be made.
See, at a OST no. At a OST no.
Yes,
OST रहता
Just to recompute.
OST रहता
Appeal effect has to be taken given by the authority. That is domain of the department.
Mr. Kedia is not forgetting OST. That has been long since repealed. It's not saved under GST also. Is it saved?
We are directing. Yes. Yes.
Two days.
4 weeks make the payments.
Item number 10.
Oh, 16-2 you have challenged.
Not 15 to 16.
You have 16-2 you have challenged. Give.
This is a similar way.
Yes.
You will achieve pass lateral 20% years to the corner.
Yes.
That is a bounce of. In that case, that is not there. But your lordship may kindly look into page 28, the adjudication order itself.
Go. Conserve energy for the next day. Yes. 20%. Don't matter.
Not
20. Yes, next.
Item number 11.
who entry and
Yes.
Item 11.
item 11 matter looking into cancellation of access.
Yes. Both.
Both sides of the table.
Yes. Who is for the other side? Next.
Item 12.
I think claim is in absence of GST present.
10%. Next.
Item 13.
Appeal is covered by justice order. I'm saying. I am submitting them.
What has happened in this case? Originally, it is the second round, my lord and sister has come before your lordship.
So, your lordship is related. Rose about from the case where I have approved this under the court, challenging the recovery notice while the order is original but not and while the order dated 29th of April, the lordship has increased to
Lordship, kindly see paragraph 5, your lordship's observation.
I also relying that order where your lordship has increased to grant the liberty to challenge the order, your lordship. So, pursuant to that liberty, lordship, I have filed this application because this barred by limitation under section 73(4)(b) of the Service Tax Act. And it is clearly covered by your lordship's order, and that is near it.
Your Lordship, kindly see the last order, page, paragraph 5. Paragraph 5 of the order. The earlier order dated 29th April 2025. May I place, Your Lordship? Since this court is persuaded that the order in original dated 31st August 2023 was never served on the petitioner, and therefore it had no occasion to challenge the demand raised thereof by way of an alternative remedy available under the statute. Order in original has been served on 24th April 2025 via email, which fact is not disputed by the Lord Senior Attorney Counsel. As submitted by the Lord Counsel, the petitioner is at liberty to challenge the said order before the appropriate firm within a period of 2 weeks.
So they have not challenged this order?
No, madam. They are challenging the order in Alja before your lordship.
Yes. Why not alternative forum?
Because your lordship is in similar circumstances, many petitions are there, and I have.
So what? So what you could have, you were relegated to a alternative forum, then you ought to have.
There is an alternative forum, your lordship.
There is no alternative forum. Why there is no alternative forum? Forum of appeal is there.
I'm not refuting that, your lordship.
So
I am only trying to convince your lordship that this under the court is also a forum to approach your lordship, because there is the order itself is barred by limitation,
okay.
And 73(4)(b) is the act itself states that in 2021 the notice has been issued. Order notice has been issued in 2023. The order has been passed. So it is completely covered by 73(4)(b) that has been violated by the department of law. That is why I am before you, let's say.
So a preliminary objection is raised by the counsel for the state that
Not statement.
CGST that a senior standing counsel that the instant writ petition does not deserve to be entertained in view of the order passed by this bench on 9/4/2025 in WP within brackets C number 10197 of 2025. According to the senior standing counsel, the same order was challenged by the petitioner in the said writ petition.
Order in original was not served on the petitioner.
Oh, that is what, but she challenged that order.
Now,
No, Lako, sorry, in Kibule submits that the recovery notice dated 14 March 2025 issued by the Assistant Commissioner Goods and Service Tax and Central Excise, HON'BLE Division, was a subject matter of challenge in the aforementioned writ petition, on the premise that the order in original was not served upon the petitioner. While disposing of the said application, this court accepted the contention of the petitioner with categorical finding that the order in original dated 31st August 2023 was never served upon the petitioner until 24th April 2025 through email, and therefore granted liberty to the petitioner to assail the said order before the appropriate forum available under the statute. It would be profitable and relevant to quote the excerpt from the said order, which runs thus, quote paragraph 5. The counsel for the petitioner submits that there is no fetter. I quoted the full. Emphasis applied. What I said? There is no fetter on the part of the petitioner in challenging the said order in original, dated 31st August 2023, on several counts. As the writ petitions raising the aforesaid questions are pending before this court. She further submits that there is a glaring infirmity in the said order dated 31st August 2023, and the alternative remedy is not a complete efficacious remedy available to the petitioner. Stop. Next one. We are not impressed with the submissions advanced by the petitioner. Stop. On a bare perusal of the observations made in paragraph 5 of the order dated 29/4/2025, as quoted here in above, the liberty was granted to the petitioner to challenge the order dated 31st August 2023 before the appropriate forum as provided in the statute. The aforesaid observations, the aforesaid liberty was necessitated on the submissions advanced before this court by the petitioner, that since the order in original was not served, there arise no option to challenge the same. As provided in the statute. A litigant cannot be permitted to approbate and reprobate at the same time. Once a specific stand was taken earlier round of litigation, that the alternative remedy provided in the statute could not be exhausted and or availed of because of the non-service of the order dated 31st August 2023, it is not open to the said litigant to approach the High Court challenging the same order instead of exhausting the statutory remedy provided in the statute. We are conscious that there is no fetter on the part of the citizen of the country to approach the court under Article 226 of the Constitution, despite the existence of an alternative remedy. Yet the High Court may refuse to exercise such discretion when the alternative remedy is found to be efficacious one. Once the liberty to challenge the said order before the forum provided in the statute was granted in an earlier writ petition, in order to maintain the judicial discipline, we do not feel that it is a fit case where the High Court should entertain such a writ petition. Accordingly, the writ petition is dismissed. Liberty is already there in the earlier order.
Item 14.
Case was granted and proceeded the last day. So maybe the date may be extended, you must say. Because even though I will file appeal, you must say, there is no time because today is the last day.
Go rush. Go and rush.
I will be highly prejudiced, you must say, because because you are the council of the revenue.
We were absolutely, I would say, liberal in the earlier matter, but no.
Only 15 days was granted when appeal.
There was a sufficient notice to you, madam. No. Sometimes one should, may I use the word, very bad word, stubborn.
Only my limited period is
No.
that extended, I will file appeal.
They rushed last day. Why?
Item 14.
May please, Madam. This is a matter of three substantive questions are involved. So, Lordship, kindly before I advert to the questions, page 49 for a moment, Madam. Page 49.
You are challenging the show.
I am challenging a show cause notice because of the apparent lack of jurisdiction. Your Lordship, yes. Page 49, Your Lordship, may kindly for
the lack of jurisdiction, it is issued by whom?
it is issued by also. There are three substantive issues that jurisdiction will not, because here, because I am registered in November 2022, Willards. And the show cause notice Your Lordship will find involved period from 2018-19 to 2021-22, Willards. Yes, adequate mechanism is provided for making assessment in respect of unregistered dealers under section 63 of the GST Act. There is also similar provision provided for making assessment in respect of registered taxpayers. Here, what has happened, Your Lordship, while drawing your Lordship's attention, page 49, they propose to demand 12 lakhs amount, which I have already paid before issuance of show cause notice. Your Lordship will find from page 48 itself, 49 itself, that an amount of 12 lakhs 10,821, being the GST liability surpaid, not paid in respect of taxable service provided, received by them, as discussed above, during the period April 18 to March 22, should not be demanded from the under section 74(1) of the Central GST Act, read with 20 IGST Act. And then my an amount of 12 lakhs 11,490 deposited by the notice should not be appropriated against the demand. So I am placing with page 49. So against the proposed demand of 12 lakhs 10,821, yes, because the assessee has already paid 12 lakhs 11,419, that is required to be appropriated, that is the proposed notice says. And the period Your Lordship may kindly see, April 18 to March 22 under 74(1). Now, Your Lordship kindly turn to page 38. Page 38. Only I am placing from paragraph 4.3, the last sentence. Page 38, paragraph 4.3, last sentence. The noticee has obtained statutory GST registration on 31/2022 minutes. So therefore, from 2018 to 30/11/2022 minutes, I am an unregistered person minutes. And the provision under which notice to be issued minutes is under GST ASMT 14 and assessment order after complying all the statutory formalities as are envisaged under Rule 100 sub Rule 2 of the GST rules is to be passed with ASMT 15 minutes. So that is complete statutory mechanism procedure available under law, how to and in what manner to assess a registered person and an unregistered person. A notice cannot be issued to an unregistered person for making assessment under 74, where admittedly on the face of the notice itself, I am unregistered till November 2022. But break from considering the liability letter form, because admittedly also that is a neutral situation, because whatever is proposed, I have already paid bills. This is one. So therefore, the very proceeding initiated under 74(1) is contrary to the very provision of GST which provides for specific procedure under section 63, substantive read with Rule 100 sub Rule 2 of the GST rules. This is one. Secondly, Your Lordship have come across many petitions these days which Your Lordship have posted to sometimes in June. This involves multiple assessment periods as well. That you lordship covered by your lordship's order, your lordship is passing. And third one, minutes. Third one, apparent bills. This is a proposed proceeding for 74. Plus, when the very payment has been made entirely prior to issue of so-called notice, because there is no prohibition part of the authority will have to go for adjudication 73. Because extended period of 5 years is available, you cannot bypass normal period and go for extended period. So 3 substantive issues are there for us. My friends, let them respond. This is only respecting to one aspect, that is multiple. But from that, 2 other aspects are also there.
Page 29, it seems only one panel.
Page 29. No. What they have done, they have issued DRC1 for all periods. But so far as this 35 is concerned, DRC1, the detailed so-called notice, it's an amalgamated notice block. It's a consolidated notice block. The lordship will find page 35. It starts from 3 to dated 3 to 25. They have taken into consideration all periods, 2018-19 to 21-22, and calculation of liability and everything. The source of info, all these are there for. It starts from page 35.
Then even separate DRC 1, 31, 23.
Yes, they have given DRC 01 notice for 4 different notices, but the detailed so-called notice which are
facts which
correct. It's a consolidated. Nothing is there here.
Amalgamated.
Correct. The source, calculation, liability, determination, everything is there here.
Consolidated.
Exactly.
Facts are
Correct. Absolutely.
But separate notices.
Separate notices are there. Separate DRC1.
It is unlike other.
No, here, my lord, the order has been passed on consolidated. Therefore, the question of limitation arises. But here, my lord, the so-called notice challenge, and as your lordship rightly pointed out, that this notice is happening for rules, and rules is provided for issuance of notice, and that is separated. But the consolidated fact has been enumerated in the form DRC1. So, my humble submission, Lord, so far as the date of effect of the registration has not been avoided in the petition, because but effect has to be made in the certificate register. That has not been enclosed in this petition. Thou will not be 30th time. He has not passed any order. This is so-called notice. He can appear and ask whatever he has urged here. Let him pass the order. Then, if he is agreed, then he has a cause of action. Here there is no cause of action at all. Because it is 30 days time has been allowed. So let my singer may appear and explain the facts. This is the date of registration, the quantification, and the payment. It is not yet considered. So therefore, my humble submission, Lord, let him file a detailed reply and pass a reason order. Then he may agree. What is agreed by this so-called notice? It is merely a so-called notice. 30 days time has been given, and yes, I don't know whether he's appear or not. That time has already been spent.
The question is what my friend is arguing. I understand appear, go and appear, file reply. But the very genesis of the notice belongs. It's under 74(1). Now let my friend read 74(1) justify. Can it be? The question, can it be? That's when section 63 is there. And apparently you cannot make a guess that the registration might have a different effect from 17. This cannot be guesswork.
Because you have not given the date of effect. You are only saying that I am not registered on that period.
You can make a reply to that.
No, why should I?
You cannot assume.
No. It is so-called notice.
No.
This is so-called notice, sir.
Notice itself is clear. all the three questions independently constitutes separate grounds of challenge so far as the inherent lack of jurisdiction to issue notice is concerned. As a matter of fact, when for a substantive period up to 2022, 18 to 22, that's about 4 years, I remain an unregistered taxpayer. Question remains whether proceeding can be initiated under section 74, which is exclusively meant to be initiated as against a registered tax person. That's the number one point. And apparently that is disclosed in the notice itself, that I am registered since November 2022. And I may not repeat at the cost of repetition. Rules are there, provision is there, and manner of assessment notices all are separately provided there. You can't embark upon the other when there is already specific provision there. It's out and out law doesn't support the stand now taken by my friend to support the justification of the notice issue. This is one. Number two, very simple thing I will also say, second substantive issue, whereas as a matter of fact, your lordship found whatever tax proposed to demand in the local notice, that 12 lakhs of what, whereas I am a stock broker, stock brokerage earlier, prior to advent of this GST was exempted from tax under service tax law. There is little cloud also all through, no clarification came. Anyway, but GST now it is taxable. We also admit it is taxable. Across the country, 90%. Why 90%? Maybe more bills. The big stock broker, those who are there operating from it, they have huge liability. Unlike the poor small operator, those who are doing here, they are not sure of the liability. But in any case, in many cases, they remain unregistered. There is no campaigning either from their side also. That is what they do also, to make awareness of the liability of the assessors. In any case, my stand here also, which I have with my reply also, which I have given at page 26, your lordship will find that 17, 18, it's below the amount which I have got. Commission is below the threshold. Whereas 18, 19, and 19, 20 below threshold. 20, 21 it just exceeded threshold. Then I applied for registration in 22. And I also, before issue of show cause notice, I paid the tax. But what is course available? Well, and the source of information which they do disclose bills is either CANFIN and this data from government sources bills, and those are available in public domain. So the recourse which they should have taken in all apparently whatever there in the statute, under 73, you cannot wait time available to initial proceeding under 73 when all information is available with you, and available extended period by invoking 74. In the copy of registration certificate, which is valid from 30th November 2022, not retrospective effect as my friend is apprehending. It's only 30/11/2022. So, I am reminded of your lordship knows constitution by character discounts case bills. When it goes to the question of jurisdiction, that's affecting the constitutional right of the assessee. It will be well, because it's very exercise. If
I'm also reminded of my own judgment on this.
My Lord, Honorable Justice Raman has also delivered a lengthy judgment
My case,
In the case of my friend, Mr. Sarpathy.
The Calcutta case has already been considered. Lordship felt that is go and
Yes.
file reply.
Yes,
No,
yes.
some Mr.
Saraswati, that is in the case of
Mitambari Misra. Mitambari Misra.
Justice.
Yes.
Justice also.
The Calcutta discount, all this judgment has been considered and your Lordship has passed that.
Including postal content.
Coastal London.
Yes.
So despite of all this, with great respect to your Lordship judgment, my Lord University Thomas judgment, but despite of that, in appropriate cases, wherever your Lordship finds that so-called notice apparently doesn't make out that case.
I have already said that what are the criteria where the court can step in at this stage of a so-called notice.
Correct. Here particularly.
So I have already laid down some of the principles which I perceive to be holding the field.
Absolutely.
I do not know. Something more has come because, and I am still open to change my mind if I have committed any other.
Then that is all.
There is any change of law.
Always your Lordship's greatness. But here particularly, that multiple period is still not left for consideration by your Lordship. Sometimes in the next month, your Lordship have kept all the matters. This can be also examined because here is a case, in any case, it involves multiple periods, number one. And secondly, my lords, these are all three substantive issues. They let them find a reply, my lords. Situation that prejudice to my friend because the revenue is not prejudice. Tax is paid also. So therefore, there will be no prejudice to my friend. Let them file a short reply, not that you may humble submission for me. So that matter can be taken up along with the other pending issues also there. That is humble submission. Yes. It's a
Pass the order. No.
it's the same order which you also passed me also.
Let us see.
Both the matters.
The tax matter and finding a withdrawal memo, and there are certain documents that I need to bring on record. Yes, you know. Yes.
Item number 15.
The section of the section for conditional delay in filing Form 10. Mandates have already decided to matter.
Yes.
Item number 16.
Sorry to make a mention, that's I am permitted to file reply notes. This matter, so-called challenging so-called. Reply to so-called.
You want to do reply, withdrawing this restriction.
Reply has already been given by you.
No, that is a reply in respect to summon, not to Sukam. Because I thought probably the judgment which your lordship referred to by your lordship lords. That may
Anticipated, you may have paused, may pause.
then I'll be deeply obliged, Lord. I'm so sorry.
No, I don't know.
My apprehension may go wrong, Lord.
We don't know. We have not acquired we have not formed any opinion as of now. So we may not, both are, well.
Then only by humble prayer, that option will be left open in the event your lordship will not be inclined. No. In the event your lordship will not upholds wills, then
No.
I will have to
withdraw, then withdraw. With liberty to file reply.
Yes. File memo. Withdraw to file.
That was,
Yes. Without details.
yes, without delay.
Yes.
16, sir. 16.
Here is a challenge to an order in original metals covering the period July 2017 to March 2019. Here, because the challenge is based on 3 grounds. Number 1, Rule 142(1)A of the GST rules requires that a notice under DRC 01A shall be issued. It is a period where shall was the provision under Rule 142(1)A, not may. Subsequently, it has become may. So when the provision says that DRC 01A shall be issued, at that time, there was no such compliance that was made. No DRC 01A was issued. Rule 142(1)A prescribed that it shall be issued. It is covered by judgment of Andhra Pradesh High Court. I'll show that. And second ground is that section 122(1)A of the GST Act came into the statute book with effect from 1st of January 2021. My 1st of January 2021.
Yes.
It came into the statute book. My period that is under consideration is up to March
Rule of section 122A.
122(1)A.
122? That's the rules.
That is section.
Section is 122A.
122(1)A. I'll give that rule.
This is rules or the act?
Section 122(1)A of GST Act.
1A is not there. 122A is there.
One is there.
I do not mind if that's so. Yes.
Yes, it's there. Your Lordship will see. Your Lordship has the professionals direct. This is
Subsequently deleted or what? This is the book.
pay 80.
No, one is here, but that book does not contain one. That's why. Anyhow, I got you.
So, Your Lordship, this provision came into the statute book with effect from 1st of January 2021. This is a penalty provision. This is a penalty provision. Now, that has been imposed upon me. A law that was not there for the concerned period, that is July 2017 to March 2019, this has been imposed. And Your Lordships,
how can you give a retrospective?
Article 20, Clause 1 comes into play.
It came on the 1st of January 2021.
Your Lordship, the notice was issued on 29 October.
I'm asking for a period. It talks about the benefit of a transaction. If the transaction ensued somewhere prior to 1/1/2021, how can you?
GST. Penalty was not there.
Yes, penalty was not.
Interpretation of feature in Tenkai. Mr. Khalid, you must be remembered. In CST Act, there was no penalty provision. Later on, it has come. It being substantive provision or interest.
Interest was
provision.
yes.
Interest. 828. Khemka is in South. So, Honorable Supreme Court has said you cannot impose interest being substantive provision which has accompanied.
Khemka is of 1970.
75.
Yes.
At 10 days
Will also.
10 days penalty.
By the then Chief Justice in this section, I will highlight some points, Your Lordship, first. First of all, Lordship, in this case, a invoice has been taken into consideration. I'll be telling you.
You can take shelter under section 120.
122, 1A, what?
Which was introduced on
2021.
in respect of a transaction which was prior to 1/1/2021. Because the language of that section itself is very clear. It says that any person who retains the benefit of a transaction covered under clause 1, 7 and 9 of subsection 1 means one talks about supplies of any goods or services without issuance of the invoices. Then 2 also they collect any invoices or bills without supply of the goods. And then it talks about the 7 talks about the utilization of the
7. This 7 is applicable in this case.
Takes or utilizes the input tax without actual receipt of the goods and all. Now it says in respect of what? The transaction, which covers under this, at whose instance such transaction is conducted, shall be liable to a penalty for an amount. Now, this when it talks about a transaction, then the transaction must be relatable to a period after coming in force of this act. The transaction cannot be relatable to a period prior to coming in force unless this amendment is intended to operate retrospectively.
Yes.
If it is, and I tell you it cannot, because in any penal provision, if it is introduced subsequently, it cannot be given a retrospective effect.
Penalty being quasi-criminal, it's fit by Article 20 clause.
My brother always talks about the taxation. I always talk about the civil. So there was a Benami Transaction Act which was there, which permits any person to enter into a Benami where they can purchase. They are the real owners and the person in whom the property is the ostensible owner. Then the Benami Transaction and Prohibition Act came in 1988-89, which prohibits that there cannot be any transaction in Benami. Whoever has committed the Benami transaction or committed an offense under this, then there was a criminal offense which was fit. The matter, the virus was challenged before the Supreme Court in Mithilesh Kumari's case. That is a judgment of 1989, Mithilesh Kumar. In Mithilesh Kumari, the Supreme Court held that it has got a retrospective effect. The fallout of this was that whatever the transaction which was entered prior to coming in force of that Prohibition Act were rendered illegal and null and void, though were legal under the Benami Transaction Act. So the thing which was done under the Act, which was legal, if subsequently there is a prohibition, cannot be rendered illegal prior to coming in force of the Act.
Then in 1992, the matter was referred to a larger bench, and the larger bench upset the judgment of the Mithilesh Kumari and said no, it can be given only a prospective effect because it invites a penal consequences. Criminality was attached. 3 years sentence was given. Now more radical change has come.
In 2016.
And lot of changes, even a power of the court is taken away.
Yes.
Vested in the various authorities of the income tax.
Income tax. They have a Benami prohibition unit. And that Benami transaction was also in 2016, the matter has been referred to the Supreme Court. And the Supreme Court has given another direction for which department has filed a review petition. Following a particular point, the asset held till now, they will be taken into consideration in a Benami. When the asset has been sold prior to 1988, that was taken into consideration, that won't be in a Benami. Benami, that will be deleted. But even now, if the asset has been held, then that will come under Benami. We have filed a review for
prohibition came, I tell you that 1988, this Benami Transaction Prohibition Act came.
Yes, it's 1988.
Which forbids any Benami transaction to be entered into. Prior to this, there were many of property. Money is given by an employer. Property that the deed is in the name of an employee who has not contributed a single penny.
One line has been added or held has been added. That has, for that reason, review has been filed.
That is why I said that you can't give a retrospective effect when it's a penal provision. When you impose the penalty, and the penalty which was not there in at the time of transaction, can you do it? That is what is the troubles.
In this case, let the this penalty will not be taken into consideration. But what he has done, he has violated and he has taken fake invoice, which he has accepted.
I accepted it. For that, whatever is the penalty provided prior to 122(1)(e), you do it. Impose. But not a penalty under 122(1)(e). If it is an interest, if it is whatever is provided prior thereto, you do it. There is no who puts a fetter in you in doing so. Because these clauses 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, which are there already, originally in section 122 is there. Totally different.
Let me take instruction in this matter also.
This is what I was just saying. That troubles.
But there also rule 142(1)(a) has not been followed, which says that it shall be issued DRC 01A. In this case, it has not been issued. DRC 01 has been issued. 01A
pre-amended stage, whatever was there, they have to take recourse.
They have not done that.
That's whatever.
And itself is invalid. I'll tell you, GRC, that 142(1)(a) is not issued. And apart from that, the third issue below is that it covers from periods.
20%.
July 2017 to March
20%.
20% of the tax.
Let's say,
yes.
Your Lordships, 10% is what the appellate provision provides.
Huh?
10% is what the appellate provision provides.
Then 10% we do it more difficult. We have given a 20% in one case.
There's the appeal says 10%.
Second, my lord, 1 week time may be granted to submit the certified copy of the imbue judgment. But is that not made due to want of well, without certified, I mean. My lord, I have applied.
It has not been given to you.
No.
Otherwise, also this order can be set aside by the single judge. They have referred to a judgment which has no connection with the facts of the present case. That is the very short. Because the Lordship will look at page 49, irrespective of the limitation, my lord. She has enclosed. But page 49, if your Lordship may kindly see, they have referred to a judgment delivered in case of 7281 of 2018.
And 4848.
My lord, that judgment is at Annexure 3, your Lordship may kindly see. This is in respect of RSCP benefits, grant of RSCP benefits, whereas the petitioner's case is with respect to the recruitment of police board.
But
So this has been done erroneously. So, and the concession also made.
No, my lord, I have not cited, my lord. My lord.
why you have made it a title matter?
I have not mentioned, my lord. At that point of time, there are so many matters.
The whole line of it. Remit it back.
Yes, that is why I said instead of.
The staff report indicates that the certificate copy of the input order has not been placed within instead of you. And therefore, does you need. After hearing the respective complaints, we dispense with the filing of the certificate copy. It is in order. It is submitted at the council appearing for the respective parties are unison on this stand that the judgment which has been relied upon having a bearing on the issues involved in the instant writ petition are in respect of the different issues which does not germane from the cause of action pleaded in the writ petition by the appellant. Since the principles laid down in the aforementioned writ petitions is applicable in relation to a cause of action pleaded therein, the instant restriction could not have been disposed of on the basis thereof. More particularly when a different cause of action is pleaded here. Solely on the ground that the impugn judgment is passed on such erroneous application of the principles decided in WP within bracket C number 7281 of 2018 and WPC number 4848 of 2021, the impugn judgment is set aside. The matter is remanded to the single bench for hearing afresh. The single bench will decide the matter on the basis of the merit to the points involved in instant appeal, after affording an opportunity of hearing to the respective parties. Which yes.
Item number 18.
My lord, this matter has been remanded by the Honorable Apex Court. And, But as such, there is no delay. So matter has to be finally heard. The Lordship may fix up a date so that after vacation, any date.
But we have not received the copy of it.
I'll serve a copy of the appeal. Earlier, in fact, copy was served, but still then I'll serve another copy. The Lordship may call you back to the issue.
What's the good name, ma'am?
Rasmita Das. Rasmita Das.
This Smita Das. For the respondent number?
The sole respondent.
Appears for the respondent. And submit that the copy of the writ appeal may be directed to be served upon her. It appears that an application for consultation of delay filed in connection with the instant appeal was rejected by this court, which was assailed before the Supreme Court. So the Supreme Court set aside this order and condoned the delay in filing the instant appeal and requested the High Court to hear out the appeal on merit. The counsel for the state is directed to serve the copy of the writ appeal upon Ms.
Rasmita Das.
Ms. Das. When?
By tomorrow. By
in course of this week.
In course of this.
In course of this week. This is the matter under the same heading. After 1 week or 2 weeks? 2 weeks after or 1 week after?
1 week after.
1 week.
2nd of July. Item 19.
Item 19. That is a delay of 1056 days. 1056 days.
Would you like to find counter or you are find counter?
Today I'm appealing. Today I'm appealing my husband delay of 1056 days months. And no reason has been assigned.
I just thought that you will be considering.
No.
Not considering. File your counter.
Copy of the writ. Copy of the writ application.
This copy of the condonation application has been served?
No, not served.
Condonation has been. What is there? He has already appeared, so no question of any motive. Or he made no motive. Give me a copy of the as we use this arrangement. In course of this week?
In course of this.
Counter already within 1 week after?
Yes, ma'am.
I'll serve copy.
Item number 20.
They have some sort of pleased to see order dated 5th of April 2025. My last friend has served the copy just today.
Why, sir, so late? You are appearing for whom? How many days delay?
As a lordship, please. Delay is substantial because I'm instructed that the reply to the delay is also ready.
Your final counter?
Not yet, Lordship. We received the copy today. In 2 days, I think we should be able to file the reply. Lordship calls it after vacation. This is Power Grid Corporation. This is central. The central government undertaking.
Yes.
Yes. Item 21.
Or should I call it 2 weeks after?
2 weeks.
21.
I'm probably responding. Delay of 185 days.
What you say, sir?
On your last occasion, Lordship said they let the argument merit. If the subsidiary limitation will not be ignored.
Yes.
Let them argue on merit, my lord.
Merit, my lord, let it come after vacation, my lord.
Last occasion, receipt will be able.
Yes. Yes, sir.
Date. Immediately after action, date.
2nd July.
2nd July.
Item 22.
Right, this is your loss. What
is this? You are not a party to the proceeding.
Yes, ma'am. Only
You are a party to the proceeding. You have sought for a leave to appeal. That's why I'm asking why. I could not make myself clear to you.
Yes, ma'am.
Whether you were a party in the writ petition or not a party to the writ petition, tell me.
Party is this.
Then why you are seeking to grant leave to file appeal as appellates? Why? It is only necessary when you are not a party but affected by an order, you sought a leave to file an appeal. Why this IAM 3? I'm looking at IA 3. No, IA 3. Understood. This is what say graciously pleased to grant leave to file the memorandum of appeal before the.
Still conversion.
To say that no. Just to.
There is also limitation, sir. Have you served? Other side.
Only file conversion, my lord, LPA to.
But there is also a delay. There is also a delay. I will more. How many days delay?
Staff report, we put it like this way, is to be hit off. So
Direct the conversion.
then it will be the, again, the staff report.
Send it to a staff report. It's not fresh reporting.
Yes.
The number of 5 was 2022. Seeking permission to convert number 406 of 2022.
It is registered as LPA 2 of 2022. Registered it. Yes, ma'am. What is that? Right.
406 of 2022.
Yes.
Yes. The idea is that this registration to convert EFTA to W.
Right. Yes. Madam. Yes. Sure. After staff reporting is done, it will be listed. Item number 23.
There is a delay of 338 days.
So I find my objection, but the objection at like F. They have said that they, after the judgment, they send the file to the office of the Advocate General, there is that and some official formalities. That is how the delay has caused.
Yesterday, the matter was posted.
You have disputed it.
But
Yes,
although
but your Lord, I said that let it be put on and let it be decided on merit. Because I have already
saying that these are their internal matter.
And that is why I said yesterday. Yeah, I do not want to carry this burden. Your Lordship said that if they will go to the Supreme Court and delay will be condoned and again. So because these people have, my lord, have suffered since last 2 decades.
What is the
That is a regularization matter. These people are
because they are not
only two grounds they have taken. My lord, one is that there was no recruitment procedure, but according to their guideline, before it is there that before they are getting an appointment, they have to undergo a training, and for training they have to come through.
We are meeting this matter immediately after vacation, and then we will decide on the one go.
Even my your lordship can see only one judge, and the latest judgment perhaps your lordship must be aware. Justice Vikramnath Jagdal.
I am aware.
Yes.
It is judgment or something.
Jago. This is the judge.
I'm aware.
And there is absolutely no backdoor entry. But they are saying.
So just keep after vacation immediately.
only today we confirm matter can be heard on merit if my lord
My lord? Yes. Patita Pavan Dattadas case has been dismissed. The writ appeal has been dismissed.
SLP pending.
But the special
Notices are issued. But so far me is concerned, my lord, that is a joint Das case has been that was also referred that the Supreme Court has dismissed their SL. And in my case, it's totally, your lordship can see that they're totally different because they are saying 2 things. Yes. No, only they are saying 2 things, that no recruitment procedure has been followed, but I have given a document which the Labor and Employment Department resolution, which says they can adopt only one method. Either they should sponsor through employment exchange or through open market. But they have sponsored through employment exchange. And we appeared in a selection test and got selected and thereafter sent for training. Yes. So we are sponsored by employment exchange, selected through a selection test, then went for training, and after successful training, they said there is no guarantee of appointment. But they were abolished 71 regular posts, get concurrence from the finance department, and given us appointment contractually. Now they are saying that no recruitment procedure has been followed. And their letter, their own appellate number 2's letter itself says that everything has been followed. I may be issued with a formal direction to give a regularization order. That they have not disputed. I have given all my details in my counter.
Have you paid the amount of energy which he is now carrying with him? You have to meet him.
But yesterday he made a mention that
of an energy.
I'll
meet all the
formidable opponent.
I'll
have to meet.
I'll meet all the objections raised by my learned friend.
Let the technicalities, the delay part be here and let it be put for present.
It's the application for confirmation of delay in filing the instant appeal against but according to the appellate is because of the procedural purposes. The same has occurred. So is stated in the said application that after the disposal of the petition by the single bench in passing the interim order, the law department sought for an opinion from the Language General of this court, whether an appeal is required to be filed or not. Subsequently, the files traveled from the different departments, and ultimately the opinion was given by the Language General to prefer appeal. So immediately thereafter, the memorandum of appeal was adopted and engrossed by the junior advocate who has been entrusted to by the instant appeal. And by that vice stand, there is a delay of more than 300 days. The respondent in the counter affidavit has denied the government's made in the said application. It is ardently submitted on behalf of the online selection. There is no merit in the instant appeal. And the state has come up before this court only to frustrate the order passed by the Supreme Court and also deny the rightful claim of the respondent, which has been held constitutionally valid. The court should confine on the explanations offered for delay. And if the court finds that the sufficient explanation has been given, which invites the donation of delay, there is no fetter on the part of the court, doing the same, irrespective of the fact that there has been actually inordinate delay in proceedings. As indicated in the said application, the delay was because of the procedures to be followed and the delay in giving an opinion for filing the appeal. We find that the appellant was prevented by a sufficient cause. The delay in filing against the police is under control. This is the matter immediately after the reopening of this court following the long vacation. Means on the reopening. Vacation. Under the heading.
Yes,
Fresh admission.
18th. Item number 24.
May
Review of whose order?
review of the honorable week of the order.
I mean, the learned judges who passed the order.
My Lord the Chief Justice and my Lord Justice Raman. Yes.
When that order was passed. What is the date of that order?
Yes.
Oh, there is no application of recognition. Objection is here. They have approved the wrong forum.
May I submit my one slide, member, sir?
Section 14, I must bring to your notice.
But last date also I said that section 14, but fact remains due diligence factor. So far section 14 is concerned, that is not there in the petition itself.
No, due diligence in section 14 is something which is very relative. Because if they have acted on the basis of advice of a lawyer and before the wrong forum, then in that event he must get an advantage of section.
May submit matters once. So far 14 is concerned, matters, let us consider the latter part matter. My humble contention, we succeeded in the matters repetition.
On merit, no difficulty.
I'm not on appeal. Appeal was dismissed against that matter. The corporation.
They went to the Supreme Court. They withdrew it with the liberty to file a review.
Their my contention. It's not a case that filing a simple review petition or condemnation of delay.
So we will come. But anyhow, they were granted a liberty by the apex court. Now they have gone to the single bench. I do not know what was the advice when the order of the division bench was.
No, sir, that single bench order merged with the order of the honorable division bench. It should have been filed.
Should have been filed here.
Should have been filed here. But fact was my humble contention. Simple humble contention.
Wrong advice and acting of bona fide on the basis of our
wrong advice, matter, kind of last petition matter.
There's the wrong advice of a lawyer.
Kind of
the division bench order is sought to be reviewed before the single bench. No.
I will be, if there is an order of the honorable Supreme Court, I should be very careful and conscious before filing a petition matters. I should be very careful enough. It's not that review petition is filed and then matters.
I am also conscious that when and how these liberties are granted. I'm conscious.
That is correct, my lord. I kind of asked that petition matters. Here also they have not settled that because of the wrong advice.
What?
Limitation petition matters.
No. They say that on the basis of lawyer has filed it. That means the lawyer has decided to file a review before the single bench.
I was not the previous lawyer. I was not the previous lawyer. Previous lawyer.
Obviously, because he has given the wrong advice, so the client has taken a change.
That is not the.
But you must inherit the liability, sir. If you have inherited the asset. No, sir, condonation. This
Condonation matters, that is condonation matters, delay matters, total delay matters. Very good proposition. 900 from odd date matter. Here in this case also the plea of wrong advice also did not been taken up. Only thing is that we filed a petition before the honorable single bench and thereafter we.
How can a single bench, one can approve a single bench is the order of the division bench. That itself shows that is the wrong.
That exactly I believe my notice. It was listed before honorable single bench for a number of times. At the same contention I raised that it cannot be maintainable, honorable single bench matters opined that it cannot be maintained. In spite of that matters.
You are accusing me.
Not only that, different matters that was listed also and before another two single bench.
I was in the civil.
Yes, minor was there. Earlier also it was listed before honorable two other benches now. The thing is that all throughout it is contended that is not maintainable. In spite of that, without withdrawing minors, they delayed the matter and filed this review petition. And on the ground, minors have already stated that.
If you see why so payment opposition, pay cost. Pay cost.
Cost is not.
You have to pay cost.
In cost measures is not a thing for 6 years, and I'm not insisting so much. The thing is that petition must be managed in the line. This justified
pay cost, sir.
And that petition is under section 5.
Pay cost.
Yes,
The petition is and I have come from a place. You should realize that how much. Not less than 6 numerical number.
Lordship may have the matter on merit. Your Lordship may have on merit.
Pay cost.
No, first for the last one.
No, so horse minors is always one party, their minors compensating, minors are compensating. But here minors, case is not made out.
So they have good case for review.
Good case for review made.
You have good case for review. You have.
Yes. To defend the review. Defend the review. That is their minor. But hearing is minors, limit is on 900 days minors. That last date minors pointed out that the mistake in the change of advocate and all that minors refer to that Supreme Court decision and the minors pointed out that minors.
That is there. The IR 1997.
97.
Point number 07 or 6.
07. Even electricity board minors. That
This paragraph itself is very damaging.
That minors, that in fact minors. Thing is that
Last paragraph so strong worded.
Minors. That listen what is, and that too one of the decision of minors in case of Jagannath Mahaprabhu minors.
We have to conserve Mr. Ashok Pani.
Thinking that minors limitation.
Since one judgment says
Without lot of him stated the region minors. The region minors after the order passed by the Honorable Supreme Court, if you are choosing a wrong forum. And that too, minors, it has been taken up number of times, and there also this point has been agitated, and in spite of that, you postulate that he is and you have not preferred appeal. And it is a petition under section 5 of the Limitation Act. Minors may exercise the power, but in that power is there, means minors are that authority is there. But the fact remains, no case is made out at all.
yes, man, I have made good case.
No case in the sense limitation.
On many I have good.
Nice. Extra copy.
Yes.
This I think in Sri Jagannath.
Another judgment, minor judgment.
I have referred to this judgment.
That judgment is there, man. Not been reported, but I could have downloaded it. That is concerning.
Same amount of cost also I use.
No, but hearing says it is something different.
Division means
That the case is something different. It's change of article.
No, that was a different case. Change of advocate.
Here, my lord says about that Jagannath Mahaprabhu case review petition which has dismissed.
That is
But my lord was party there.
that is also change of advocate.
Change of article. Yes, that it's a big judgment.
Review some other concept.
That I'll back out.
Danadaksha Seva. Danadaksha Seva.
Danadaksha Seva. There was a fine and it was dismissed.
Review another set of lawyers.
That was dismissed there.
And in a division bench we pass.
Has not been reported, but I can download it. I can download it. That decision minors report. That is it. Minor knows that minors, it status called for minors only.
One judgment.
I could not have opposed it had it been minors.
96 Supreme Court.
Mm-hmm.
1065, page 1065, last but one page. Last part, it is notorious and common knowledge that delay in more than 60% of the cases filed in this court, be it by private party or the state, are barred by limitation, and this court generally adopts a liberal approach in condonation of delay, finding somewhat sufficient cause to decide the appeal on merit.
Water has thrown in the minimum number of decisions in this regard. Minors refer to decisions and that to review petition, particularly concerning review petition.
Later on, the departure has been made. That the state cannot be
Yes, my lord, yes.
Privileged litigant.
Privileged.
And
So whenever the states will come for a condemnation, this expression will be used by us. Yes, Mr. Das. We use those expressions. Very nice expressions have been used in the judgment of the Supreme Court. And
This case.
State of Haryana versus Chandraman.
Yes.
But living in media is otherwise.
Yes.
Krishna has I produced that's useless. The BBC number 1556 2016.
I got if you are not having multiples, I have good.
XMP number matters.
Number is there.
I give that. It is 29/3/2023.
Withdraw. You are seeking liberty to challenge the order in review. Why is not on. Signatures asked to since the removal of the private signatures, let's go. Seeking a review of quantitative services. Very helpful. We will process that.
As per the, as pointed out by stamp reporting, the variance of 776 rupees is sufficient by the should finally corporation. Okay. Recently, previous finding the review, pursuing the review, around which policy. Would be which more liberally it is inconceivable. As of
It's a corporation, the corporation, 1 lakh.
In single bench, I used to say that 1 lakh.
Are your losses 20%?
You suggest, you have been appearing for many corporations and
I am
other.
not at all on their minors, whatever minors decides once I am not standing in way. But my humble conclusion is that it cannot be conducted. Whatever
That we have decided.
accepting that minors,
Now that chapter is over.
accepting that whatever minors man decide once is purely.
Now this chapter is opened by my brother. Now tell us.
Yes, bro. That minors decide. I
Give
leave
it
it to minors.
10 to 20,000.
I leave it on minors.
You are a Odisha left
Irrigation Corporation.
corporation limited.
Government of
Government of Odisha undertaking.
Government of Odisha.
It is now running or become?
Running minor, but loss.
How good will
In loss.
How that is a different topic.
Our profit making organization.
Most of this 25% to be deposited on the 4 weeks from today. With the
Yes, admission. But
in default of the deposit of the cost as imposed above within the time limited therefore. This order shall stand automatically recalled as a consequence whereof the application for condonation of delay shall be deemed to have been dismissed.
Just making minutes that it is so that it will take some time.
Subject to the.
Subject, but that obviously means unless or until that then the case goes. Then the case goes.
item 25.
All right, man, I'll file a memo after that certificate over.
Because the lordship is on the last occasion directed.
25, we have filed an affidavit indicating the action taken against the teachers, those who had.
Fake certificates.
Fake certificates, teachers getting appointment fake certificates. They have filed an affidavit.
You have been appointed as a weaker CSM. So there were 3 districts.
6 districts, my lord.
Oh, last time it was said that the status report, 3 districts.
The lordship had said regarding 3 districts, but we are filing the affidavit. It is in respect of 6 districts.
They left out actually, left out 3 districts. Now they're giving a comprehensive report on that.
So 28 teachers were found to have got appointment on the basis of fake certificate. Against 20, the departmental proceedings are pending. 6 have been terminated from service, and two of them out of 2, 1 has already resigned and left. And another case, madam, that is pending. I am filing this affidavit today. I am serving a copy on my letter.
I am appealing, I'm filing application for intervention, bringing on
the teachers who have been thrown out.
No. Not taking any action against the person who are continuing on the basis of the fake certificate.
Not?
They are continuing on the basis of fake certificate, but no action is taken.
No, they have disclosed in the affidavit that.
That's why I am filing an application. I have intervention.
I have said.
Bringing on record that
we have 28 people.
Yes, sir.
Who were really working on the basis of a fake certificate, or they got the employment on the basis of fake certificate.
Yes, sir.
Out of that, 6 already been thrown out.
Yes.
1 has resigned and gone out.
And 1 case found to be genuine.
And
one case
they say is a genuine one. 20 cases, disciplinary proceeding has already been initiated pending. So they will activate it immediately.
And in respect of out of that, whether I don't know whether that report of the state government includes the name of the person who is against whom I'm filing. So I am there.
Who are you? Why you want to intervene in?
To speak on record about the continuance of the teacher.
Tell me, who are you?
I am a social service person of that locality.
This is a PIL or what?
Yes, sir.
A letter PI. Address to your lordship.
So serve the copy for what is there upon the.
Yes, I am serving, madam.
Sir, which IA is there?
It's not registered.
Not registered. You and file it in the department.
In the registry.
Whatever.
Yes.
You file your application of intervention.
the state hands over the comprehensive affidavit indicating the indicating the identification of the 28 teachers who were presumably found to have obtained employment by using the fake certificate. So it is revealed that out of 28 such persons, disciplinary proceeding against 20 people have already been initiated. Yes. And likely to reach to its logical end at an earliest. It is further disclosed that 6 persons have already been removed from service, whereas 1 person, sensing the disciplinary proceeding may culminate into the order of removal from service, resigned, and such a resignation has been accepted. So, 1 person so far as the remaining 1 person is concerned, subsequently it was found that the certificate which is submitted at the time of employment is genuine and therefore does not come within the peripheral of those 28 persons. The copy of this affidavit is served upon the amicus curiae who intended to go through the same so that he can assist the court on the next day when the matter would be listed. What's your good name? Mr.
Diptiranjan Mahapatra.
Mr. Diptiranjan Mahapatra, who advocate appears and intended to intervene in the proceedings. According to him, there are several teachers across the state who got employment by using the fake and the spurious certificate. Stop. Liberty is granted to the intervener to make an application in course of this week.
In course of the 2 days, because I am
In
ready with
course of this week, which shall be listed on the next date of listing. This is the matter 2 weeks after. And please also disclose. The state is directed to disclose the progress of the disciplinary proceedings initiated against the aforementioned 20 persons on the said date of listing. Call the next.
Item 26.
This public interest matter. It is a concept, business problems and other problems are in a PA.
I think my brother is more converted than me. Gradually, I will definitely.
Actually, there is a special bench constituted only to hear this PI because the issues are specific to the So that bench, my lords, was kept in abeyance, my lords, in January. Since then, this PIL has also not been listed. Now, my lord, it has come up before my lordships. Yes.
We'll take up.
My lords. The various orders, my lords, were passed in the last week of the year.
I have seen from the several orders. Now, today, what more? What is
I am appointed as an amicus curiae regarding a box drain, my lord.
Box drain.
Box drain. There is a drain.
And those are to be covered with with some certain plank or something is to be put over it, so that nobody can fall.
Yes, ma'am.
No less than fundamentally.
Okay.
There is a
Proposal for construction of new 4 box drain pillars.
This
There is a proposal by the government, by the Cuttack Municipal Corporation, to construct 4 box drain pillars, new box drain pillars, which will link the main box drain pillars.
Box drain means over which the road runs.
Exactly.
Yes, ma'am.
Well, as I can, with my lord's permission, I may apprise.
2.559 kilometers of box drain. Out of that, already box drain, there is a drain that will be covered. And road, there will be a road, both the sides road will pass. In between, there is in 2 drains are separated, combined together, slabs is done. There is 2 roads in 2 sides, the plywoods.
Okay.
And vehicles can go in both the ways. From Samaj office, there is the Samaj office, and there is from about 2.559 kilometers. Out of that, 17.80 meter is box drain. The rest, because for the inconvenience of the falling of the building and other, 810 meters is the open drain. Out of that, box drain is completed, and out of open drain, 63 meters is to be done. And that as per the last meeting, it was scheduled that it will be completed by May 31st. Yesterday I have gone to the site and I have seen that 63 kilometers.
If you put a box, I do not know, during the rainy season,
I'm telling you,
if there is a high flow of water, so will it not overflow or will it not block or create some kind of a situation?
No, my lord.
Water accumulation. Okay.
Water
from here is if you cover it.
not
It is flat now. Slab is road.
Mr. Mahan, video outside. Video. Can you pass?
Then there is the connecting drains are there. All the drains are connected.
All waters also flows through that drain.
Yes, ma'am. All the drains will be passed.
As a sewerage system.
Several drains.
Sewerage, uses a sewerage system.
Sewerage system is not there. Sewerage is separate.
Then what is this drain?
This is the main drains where all the water, all Kotak towns, all water passes through the river Kajul.
No, there are two different things. I'm talking about there are sewerage drains are there through which it is connected to each houses or each area and all everything. The farm waters or whatever. This thing that flows through it, and there must be a mechanism to make it I would say environmental friendly, not to be thrown in the river as it is.
Now,
And there is one canal which I am concerned with. These canals are really an offshoot of the river, where the river water that flows, and it is very good for the irrigation purposes, because there are certain places where it cannot. There are, because I have come from a city of Calcutta, we have that canal. So, and the drainage system is different because it is a sewerage system.
No, sewerage is sewerage is now underground.
True, there also.
So that's
Throughout.
different.
So now what is this drain?
Main drain. There is a main drain.
All these sewerage water that goes and mixes there.
Yes.
Okay.
All
And
the
then
drains
from
should be
there,
all the drains should be connected to this main drain. And this main drain takes the all water, it goes to the river. Yes.
Is there any water treatment plant?
Yes. Yes, there is a water treatment plant. Yes, there is a water treatment plant.
Because it will contain many
No, there is no water treatment. For that purpose,
materials like a plastic, this one, and there should be sometimes there may be a blockage.
no, there is any water treatment plant. No problem.
And what about the clearance of the blockage? Because
That is important. For in every space about 2 meters, 3 meters, or 200 meters, we have got a manhole.
Okay.
Both the sides. So that we clean it. Suppose it's there, manhole covered it, then we drain it to that side. There are two drains, one drain and another drain. There is a bar. Suppose this drain does not work, this drain should operate. This is a Japanese technology has been adopted here.
In some places, I have seen that three drains to the Tandoon, which is now box drain. That is blocked by some material. They are not released, or suction is not used.
I'll just clarify.
The suction machinery were not put in place.
I'll clarify what is happening. Look, this box drain concept came into the city primarily because we had huge open drains which had no covers at all. So those drains were occupying most part of the road and they were creating congestions in years. So the government came up with a plan that we should not only cover those drains, but also use the space for roads. That was the whole idea behind a box drain. The idea now, apart from box drains, what we also have are surface drains. So these are tertiary drains that take water away from every household gradually and they merge into the box drain. Ultimately, all this water is channeled into a water treatment plant. There are various plants. And accordingly, the treated water is left into the river. That is the idea. This is, my lords, at almost at the stage of completion, as my learned senior was pointing out. Almost, I think 90% of that box drain is complete.
100%.
No, the last part is still there. That last 10% that's supposed to now.
Small stretch is still there.
That small part should be completed by the 31st of May. That is the timeline given. What has happened is, until that last part is complete, we are not able to channelize all that water to the water treatment plant. So as of right now, that water is going to the river. Once that part is completed, my lords, all the water will go to the WPTs and then
most gravity.
Now
you can't, because you can't pollute this river.
No, man.
You cannot do it because it has its own ecology.
So that stopgap arrangement is only for this period until the water is complete and the drain is complete and the water is clean.
Have you taken care of during the rainy seasons when there is a rainfall and suddenly the flow of water
that's really increases that until the drain is completely over, my lords, that problem will remain. So what we are trying to do is minimize the problem by using water pumps across the city wherever they are, and then pump that water out into the drain and finally.
But it is insufficient, Millers. During the
have you kept these drains at a low land area, or it is at the high land area?
No, all the surface drains.
Because by this time when I travel, I find that the roads are at the very elevated.
No, that survey has been done.
There are the residential or other areas which are at the low land.
And we have gone.
In case of any rain, then the water that goes to the low, that's the tendency of water that goes to the low area.
My lord,
the gravity. So it goes, and there will be accumulation for many times. Then you'll have to pump it up.
Yes,
So if the drain is at the low land, beneath the surface,
Right.
as you say, then you can clear out through those drains very easily.
My
lord, this is
the problem that we face in the city is lack of awareness amongst the people. So what happens is they dump everything into the drainage. No matter how much we're still trying to sensitize. So what happens is, as an accumulation of decomposition, there's a lot of silt that accumulates. So periodical evacuation and lifting of that silt is
Are you
necessary.
not trying to establish a compactors here?
Already, my lords. But it will take time because, my lords, as I said, my lords, everybody is in the habit here of dumping everything into the drains that we are trying to eliminate. But it's a problem that's now slowly getting solved.
No, it's true.
Right.
The depth of this drain is 30 feet, 30 meter. It's very, very deep drain.
It's true, that should be because.
Yeah, all will
the
go.
water-
Because till today, no drains have been connected properly. That's why the
He
overflow.
says that because of that
That's
stretch
only-
having not completed.
That's only.
So all could not.
All the water will
In
go
fact, there are
there.
three different aspects. One is, my lord would have seen probably the main canal that runs through the city. That's now being beautified. In fact, because of this last part that remains, we are now forced to release some of that water into the canal, which should not be happening. So at various stages, there are different proposals that all the surface drains that are there, those surface drains should be complete. They should not discharge into the canal, but they should discharge into the main box drain that we are talking about. So there was a feasibility proposal, and we are now trying to eliminate that thing by diverting those drains only to the box drain and not to the canal itself. So what, my lords, I would pray my lords to do is take up these issues one by one. In fact, I have written all those orders I have with me, the last orders that were passed from the order sheet. I can then intimate my lords as to what remains to be complied with. My lords can then take that issue one.
In addition to this, there is a lot of about medical, there is a lot of problems is there, and it's issue over and the roads and all the, there was an advocate committee. They are looking after those things. And
I'll give a small background. It will be easier to understand what this PIL is all about. When the 99 super cyclone, when the city was completely destroyed, my lords, there was some delay in giving the infrastructure facilities back to the citizens. So, my lords, this Honorable Court took up that task specifically and directed the executives to perform the work as soon as possible. That monitoring went on until the year 2019, when the PIL was finally disposed of. In 2020, this PIL again took the shape because of the multifarious problems plaguing the city. So, what we are dealing with this PIL, in this PIL, my lords, is all problems that are specific to this city, starting from garbage to stray cattle, to mosquitoes, to the medical college and hospital that is already the Receive Medical College, and to the Postgraduate Institute of Pediatrics that is adjoining our Honorable Court. So all these issues are taken up one by one and solved.
That matter that also came before us. Earlier. There is already an administrative building which has already come out, but there is no connection from the sewerage line could not be connected.
So that's
and the reason being that they cannot make it functional. It becomes just in such situations and depriving the many, I would say, the beneficiary of those health sectors if you do not make it operational. That is the whole. Then what are you doing? Other day it says that the municipal corporation, the Cuttack has taken the responsibility.
But they don't.
And there was a deadline which is fixed that within which they have to just complete that particular drainage work and join the same with the main one. As you say, the box drain or something. They have to join it. So but it is your responsibility also to take care of that.
Without doubt.
So I think the municipal affairs is also coming within the
yes
part of the state mandate.
It's a separate body, but
the statutory body that is, and who has created a statute?
Milas, there is no
can't shirk your
absolutely not. We are not.
This is how we wanted that you should monitor, because these things are for this fringe issues. There is a complete delay. This is not expected.
And you are supposed to file one which seems.
In fact, I have a list of compliances to done. I'll just point those out, my lords, so my lords can have a look at the others specifically.
Last order. Last order.
My lords, order number 234, dated 16/1/25.
237.
My lords.
Order number 237, it seems, is the last order. 16/1/2025.
16/1/25, my lords, 234, 235, 236, and 237. 4 orders that to be complied. 234 relates to the machines that will be.
Praise the steps taken for facilitating removal of garbage in front of regular market area
Ma'am.
and one temple area.
No, this has been already been assigned to the. Then why this account? I don't know.
When the special bench was kept in abeyance.
Mr. He told that he will take up.
I am also very much keen to understand that, but still, when I find there is already a bench, and the bench has taken an endeavor to pick up the many issues. I think the bench is quite aware of all the issues which are there. So it is better to be listed before the same bench. Though I am very keen to understand, because there's an understanding of the city where I am living. I should know. It appears that this the instant PIL was assigned to a A division bench comprising of Justice, comprising of Sri S.K. Sahu and V. Narayan's nursing, JJ, but subsequently the same was directed to be listed before the bench dealing with the public interest litigation by the acting Chief Justice. The matter is placed because of the assignment, because of the order of the acting Chief Justice before this bench. After going through the several orders passed in the instant public interest litigation and taking into account the issues germane from the pleadings as well as the stand taken by the respective counsels, we feel that the bench which has the bench which was taking up the said matter should be allowed to take up the said matter, the instant matter, so as the continuity in addressing the issues are not lost. Place the matter before the Chief Justice in his administrative side for reassignment of the instant PIL to the above mentioned bench. I have given a direction on myself. Your Lordship, so that I cannot depart from my judicial order. Oh, there has to be a sign, sir. To go back. I didn't know.
If possible, before vacation. If possible, before vacation.
Sir, it will be done today itself. I have given assignment. Now it has to be listed there.
Okay.
It's called
Item number 27.
27 Malad.
This was assigned to my land senior.
In this case, yeah, the reach of the is not mentioned. Apart from that, we know. What? I was fourth year in a school, not getting salary. Even since 1996, and the order was passed. Thereafter, review application was filed in the High Court.
The delay has been controlled.
And the review application was rejected. Appeal is against dismissal of review application is not matter. That should be settled. The review application has been rejected. Then review asked for order 47 rule 7. Because there is not a principle of merger here. Dismissal of a case, review. Had it been allowed, there would have been that's settled.
27.
Otherwise also, because as we are now also following related to letter patent appeal of the partner.
What?
Letter patent appeal, three topics. This is a partner model we are now also following related to this. All the high courts, they have already constructed related to their letter patent appeal. Belgaum is having there also Patna. Only 1 cross 10 we have taken from the camera. The letter patent. That appeal will only anything that is incorporated in the Orissa High Court rule. That this then that only gives the power of the spirit of it.
No, in Calcutta, the latest patent, which was there, that clause 15 talks about that what should be the judgment which is amenable to be appealed before the division.
And then the original jurisdiction, what happened?
That's you are absolutely correct. There the appellate jurisdiction is also there of the writ. It is in the appellate side. There are two sides in the Calcutta. One is the original side, another is an appellate side. Even in the appellate side, there are writs which are taken up by the single thing. And by virtue of the latest patent, the appeal lies, this clause 15, to the division writ. That's an inter-court appeal. So there, the question that arose whether a rejection of a review application is an appellable order or not.
Now, what happens in reference? In if suppose a single bench order is passed in a writ petition now. It's the order in the writ petition. In a civil matter, then the second appeal, there is no.
No, that is under the court of procedure.
As per civil procedure, court is going on.
Correct.
Now, related to this appeal, which is there as per the order, there must be an order. It is relating to 225 of the Constitution. Now, what
What is
happens?
the remedy? I tell you, there are two ways. Sir, if it arises from a civil proceedings.
Yes, that's why it differs.
The civil proceedings, then if the review is rejected, then one can go under section 115 of the Code of Procedure to file a revision if the appeal is not a remedy available. That remedy is still available to a litigant against the order rejecting the review. But so far as the writ proceedings are concerned here, there is no power of revision which is given in the latest patent. And that 115 like or something is conspicuously absent.
Above that, because suppose there will be a judgment that is appealable, judgment is inside, will be received appealable. Because the wording is like this, you can see. Subject to this is chapter 8, procedure before admission of the High Court related to it has been incorporated here. Subject to Article 12 of the Orissa High Court Order 1948. Every appeal to the High Court under Article 4 thereof, read with clause 10 of the lecture patent constituting the High Court of Judicature and Patent from the judgment. Now, from the judgment, that bracket not being a judgment passed in the exercise of appellate jurisdiction in respect of decree or order, exclusions are there in the bracket.
Then first and foremost thing is what should come within the purview of a judgment.
That is why suppose one single bench has passed on order judgment.
Then I think
Then a review application is rejected.
then
not a judgment.
Then the Supreme Court, the Babulal case has to be understood in that what will constitute a judgment.
Yes, because what happens here, and it will suppose review application after single bench judgment, repeat. That is appealable.
That is what I am saying. There are two aspects. One aspect is a review against, an appeal against an order rejecting a review application not permissible under Order 47, Rule 7. No doubt. Secondly, an appeal would lie to a division bench against the judgment of the single. Now, the judgment is not defined anywhere. Then what would constitute a judgment? Rejection of a review application would constitute a judgment, or it will be no judgment at all.
Therefore, I am that when not to some extent, I submitted that we have to also go relating to principle of merger.
No, you are. I'm conscious, quite conscious. So far as review is concerned, Order 47, Rule 7. Has given a very clear message in this regard. The moment the review is allowed, the judgment which is reviewed it loses its effect and that merges with the subsequent judgment of the review passed in the review. But if it is rejected, because the court is not really deciding the or testing the judgment on all parameters, like an appellate court. Not. It is deciding a review application under a very limited compass. So the review jurisdiction is an ancillary to or supplemental to a main jurisdiction, but cannot be akin to an appellate jurisdiction. So question of merger definitely will not arise. I am conscious there is no difficulty, but the difficulty is the word judgment, which is used in those letters patent.
Here another point is regulatory couple of judgments are there, mirror. Here what happened, the acts are quite different here. Comma different. Earlier what happened, there was the administrative tribunal in state, Orissa state, under the provisions of the Administrative Tribunal Act 85.
Correct.
This case was filed before that. Initially, it was a case before the Odisha Administrative Tribunal because the power was there. Judgment was passed by the Administrative Tribunal in favor of the petitioner in the second round litigation. The pure fighting related with silence. Now, second judgment, which was passed in the year 16, thereafter, review application was filed in the 18, thereafter 2 years. Special statute said 1 month time related with this. Special statute itself said relating to conduct 1 month. Then in 18, it was filed. Thereafter, what happened? Tribunal abolished in 19. Therefore, whatever pending cases, it was transferred to High Court. Then in the High Court, what happened? Review was taken up. That review, which is 2 years back and delayed. This Honorable Court rejected the review application. Otherwise, he had taken everything. One of the main grounds which is that there is no petition for limitation. That was the ground, there was no limit. Therefore, delay was not condoned. And on another point, he rejected it.
That point has been decided in full court, full bench of city. That's point. If special statute does not provide for any condonation of delay provision, then whether section 5 of the limitation act would act.
It is.
So that is decided in.
That is full court. I am not on that mirror. There was the power of election.
No, there was power to go. There was no application which was taken.
What happened here? I am not on that. Relation will be. Suppose there are 2 years delay. Now the statute says that my not is correct. Relation with this for the full bench was there. I was not going in that case. In exceptional situation, exceptional cases relating to applicability of section 5 to 20 of the limitations, where it is applicable, that's a chapter.
That's under the special act has.
Yes, that's what happened. The Honorable Court, while dealing with the matter, said that you have not filed any limitation petition. Next also, then what happened? It was rejected. Each order against that. This other merits of it coming in relation to this. Honorable Court, while admitting the matter, has said that you don't take any corrective action. Is it terrible? Therefore, this peer is not getting anything. He is also sitting it, that is not getting it. Now, question is, can you see the order which was passed by this Honorable Court? That is the reason which was given at the time of admission. It was also delayed here 1 year. After 1 year delay, that was condoned here. Unlike that, the power of delay in the appeal suppose related to this applicability of section 5. Thereafter, what happened is the reason which was given at the time of admission by this Honorable Court, that is, in one para it has been stated.
Then, sir, if you make a extensive argument, then I have many things to say. I tell you very frankly. I'm telling you the difficulty is because then I have to really apply my mind in relation to the special, I think the latest patent or the order, which really govern the field of the jurisdiction to be exercised by the High Court. I have to just go through it because I have taken one view.
I have
taken one view in this
I am narrowing, I am comparing.
And I do not want to disclose what view I have taken because the the judgment has been delivered there, obviously.
I am just comparing the view only for relate to this. It's an academic discussion which we made also. Honorable Court said that oral submission can do relating to condemnation of delay. This is the situation.
My view is again, I have taken a decision that I say,
yes, sir.
Is it mandatory that an application under Section 5 of the Limitation Act is to be filed in every judicial proceedings?
May not be.
Section 5 does not talk about any application to be filed in this regard.
No,
the power of the condonation. So I have heard there that even if there is no application, if at the time of an hearing, if the court finds that the appellant is prevented by a sufficient cause, there is no fetter on the part of the court to condone the delay.
Yeah, that is correct. That view also I am admitting, Miller. I am not deferring that view. What happened, Miller? I am just going inside related to this. If minor will time, give me time. One para kindly say, I am not. This order which was passed in phase 3, I am admitting even that position related to this. If further submit to the ground that although in every state review application, it has been explained as to why the delay has been caused in filing the review application, that has not been taken into account, and the approach of the Lord Single Judge, according to him, is pedantic. When the second position of law is that even on oral submission, delay can be condoned if the court is satisfied that the party was prevented by sufficient cause during the period of delay.
So that is what I said.
There are two submissions are there. One is that has to be written, that should be explained. That has not been there. What is the delay? I am not on that principle. Second, because the reason has not been explained. Suppose minor passes one order that this is the reason I am satisfied, all right. Related in exceptional cases. Or else what will happen? High Court rule says you file every petition supported by affidavit. In High Court rule said, then what will be there? All the petitions will be filed or oral submissions will be given related to this even content. That must be a rule. Or it will be harmonious. The orders must be. These are the reasons. This is 1 minute. The review application itself says that the delay, what is the delay suppose? Let us examine that portion. Even in the review application itself, there is no ground stated. Nothing is stated. Will kindly please.
Sir, we are on the condonation application, I believe so. Is the condonation has been done in your case?
Yes, sir.
Yes, sir. Condonation has been done. So it is only for the admission of the
data
appeal. Yes. Against the order of rejecting the review application. Yes. What is the writ rules framed by the High Court here? Writ rules. Is there any rules framed by the High Court in relation to Article 246 of the
Article 15.
Chapter 15 of the High Court rules.
15 of the HARISH.
Yeah. So this is the rule. It is framed under Section 123 of the Code of Procedure.
Yes, possibly.
There is a source of power. There is no other power where the High Court can make it rules. That is what I am asking.
Yes, sir. That says rules case possibly discuss that.
But if any petition is filed, it will be supported by affidavit as per the rule.
Sir, by order dated 5/12/2023. In presence of Mr. Alsama. This application has been allowed. So now there is no point in condemnation of delay. It has already been done.
Your I-12/1/2023 order.
I did not be correct. You should.
Great appeal was filed, yes, in the previous order. Great appeal filed 1 year later. That was condemned already. It was condemned. But now I am getting to. Now this order which was filed is related to the arbitration. That is 5/12/23. My lord, that order. That order said. Yes.
Why the PIL is also.
This 5/12.
Big one.
Sometime we will be and this sheet.
Let us have another day for very good academics discussion. I will be a very active participant there and we'll have those. So tell us, sir, when we can fix the matter. That's a very interesting point. I will come more ready on this so that we can have a very meaningful dialogue or exchange of ideas on this.
I am only aggrieved only for one reason.
When we can fix the matter.
Interim order was passed not to take any corrective action. Therefore, content petition in which direction was given for appearance of the secretary to release the salary that has been kept in abeyance.
This prevalence is 2023. Now I'm very much keen because the point of law is very interesting.
Any earlier date why not will say because of this predicament.
Whatever, tell us any day suggested. Suggest it. Your convenience.
Because that's without only review.
Yes, sir. No, it's interesting. Whether the appeal would lie against the order rejecting a review.
But he is not challenging. It is only the review order which is challenged.
Yes, tell us when.
After reopening, might not after convenience of minor, I will understand.
No, tell us when. Immediately after reopening or?
Nineteen or 20, any day from there. After vacation.
Yes.
19.
I was thinking that Odisha should frame this order related to Panta that is followed now. Same thing only extracted. Suppose one.
Where?
Because suppose they have already done. But my post after separation. So will bring this. I would say that is academic matter on secretary.
Please read that judgment of Babulal Khimji's case. For this younger, find out whether is that these young generations.
There are so many judgments of people minors said, oral submission, whatever minors have said, that have gone through. Related very exceptional matter.
There is no difficulty. It's not a routine.
Yes, that is
absolutely correct. But in an exceptional cases, definitely.
Yes, that can be done. Suppose.
What is that? The citation Babulal Khimji's.
On that day, can we take off? It's on 2 p.m.
No.
Yes, just checking them.
Babulal Khimji, Khimji, I think. Babulal.
Yes.
Yes, yes.
Yes.
Babulal.
Babulal.
It's a classical judgment on the interpretation of the word judgment appearing in the
I will
legislature.
place all my documents in my favor and in my against them. There's no difficulty in it. I will take up at 2 p.m. at least.
AIM 1981 1786.
Yes.
81.
Yeah, 1980.
81.
Right.
Supreme Court 178.
Please go through that. I think that would clinch or throw some light on that. Yes.
Item 28.
19.
It will be taken up for
19, sir.
19th.
At 2 Will it be convenient for you to?
No, I
will be here.
What says
Senior
that?
counsel, I'm just asking.
He said that that there will be a possibility of taking up case. That is saying that take up at 2 p.m.
In the body, fresh mind. Whatever suggest 2 p.m. 2 p.m.
Already programmed. But yes, so that will be relieved that we know that it will be taken up at.
Yes.
28.
This is that matter where there were two expert committees, there were two expert reports, and therefore the select list changed and the marks changed. The question was whether cutoff marks selected secured by the last selected candidate can be revised by the OPC. But I prepared a convenient, because the documents are voluminous, and prepared convenience compilations. The Lordship may have page 1. The Odisha Public Service Commission, we issued an advertisement for recruitment to the posts of dental surgeon group A. And this was in 2017-18. Advertisement number 15 of 17-18. Lordship will see at the top. And at serial number, paragraph number 2, your Lordship will see the vacancy positions.
Correct.
So there are a total of 198 vacancies. And for unreserved, there are 126.
What is this 38W? Means
Women. Women. Horizontal reservation for
Horizontal.
women. Yes.
Horizontal reservation. Yes.
Now, if your Lordship sees over the page, clause 6 is the method of selection.
Yes.
And the method of selection is to be on the, there is an underlined portion on the basis of career marking and written test. And the written test is provided under 6B. Total marks is 200. Total number of questions is 200, which shall be of the multiple choice questions MCQ pattern. No negative marking for wrong answers. And qualifying mark 50% for UR and SCBC, 45% for PWD, and 40% for SCST. In aggregate, taking together both career and written test marking. Now, my lords may kindly have the next document at paragraph 10. In paragraph 10, my lords, the state government wrote to the OPSC stating that there were several cases filed in respect of these in respect of this advertisement, and at page 11, last paragraph, they say declare the result of 121 posts of dental surgeon out of 126 posts of the UR category. So five posts were kept reserved in respect of some other writ petitions, and 121 posts were to be declared. So as Odisha Public Service Commission conducted the examination, and finally at page 12, a select list was prepared. Page 12 is the final select list.
It talks about 171 candidates.
171 minutes, 25 posts.
Whereas you were to
fill up 198. I was supposed to fill up 198 in total.
Yes.
I recommended 171. The reason is provided at page 16. Why I filled up 171 instead of 190.
Because 5, I understand you have kept
22 were not filled up.
193. So 193, then why 170?
Means 22 were not filled up due to non-availability of eligible ST category candidates,
Where?
scheduled tribe candidates.
Where do I get it?
But at page 16, we have given the reason. Page 16.
Yes.
So this is a summary. 22 were not filled up due to non-availability.
This was 5 was under the unreserved category.
Yes, ma'am. In the present case,
SC, the full 29, what it says?
Yes, ma'am.
What, blank?
No, all posts were filled up in the SC category.
Oh, recommended. Sir.
Recommended, yes.
And then 21 was recommended, 22 were not filled up, non-availability of the ST category.
Yes, ma'am. In the present case, we are only concerned with the UR category.
Okay.
I will only take your lordships to page 14 because here I have to show your lordships the marks secured by the last candidates, by the last selected candidates. If your lordships have page 14,
120.74.
for the UR category, UR category, 121 posts. If your lordship has serial number 120 at page 14,
yes.
She is a UR female category candidate.
Okay.
And she has secured 188.366. This is serial number 120. Then there is one PWD category candidate at 145. So 120 plus one PWD category candidate, 121 posts. Now, the respondents in this case are UR male category. So UR male, your lordships will see the last selected UR male is serial number 113, and that is the relevant person for the present case. Serial number 113, Haripada Das, UR, gender M, mark secured 189.558. Your lordship will only note, I will show it to your lordships later on. One respondent, Sanjay Panda, scored 184.210. Another respondent, Anil Kumar Sahu, secured 187.002. They were not selected. Now, let's kindly have page 17. 17. Government of Odisha informs OPSC that 5 candidates did not join. 4 UR candidates and 1 SC candidates. And in the last paragraph, they say it is therefore requested to recommend the names of 5 dental surgeons from the available selected list as per the aforesaid breakup, if available, to this department immediately for consideration of their posting at the earliest. So, therefore, at page 18, over the page, we recommended another 5 candidates. And their marks are at serial number at page number 19. At page number 19, serial number 4 is another UR male, Devashish Sahu, 180.
Why SC candidate you recommended when it was all?
No, if your lordship sees page 17, 4 UR, 1 SC was required.
But 5 we have shown there in UR only, page 16. On the right hand side top, 5 posts reserved as per the government letter.
Well, that's a separate category. Those are still at this point, they were still kept reserved in terms of the interim orders in other requisitions. Page 17 is that out of the 121 people, some people did not join. They did not report to their place of posting.
Under UR.
Under 4 people under UR and 1 person under SC. So we gave the names of another 4 UR people. One of them is Devashish Sahu, 187.934. So your lordship saw that in the first list,
it was 189.558. That was the marks secured by the last selected candidate. And now it has reduced to 187.934 because 4 people did not join. Then my lords, we come to page 20. When the answer key for the multiple choice questions was released, allegations were received from several quarters, from several candidates, that the answer key published by OPSC experts was wrong. And as many as 15 questions were wrong. So Odisha Public Service Commission set up a fresh expert committee using from local experts from SCB Medical College, Cuttack. Your Lordships may kindly have the relevant portion at page 23, paragraph 9. Your Lordships have page 23, para 9. Taking into consideration the submissions made by the learned counsel for the parties, this court is of the considered opinion that since pursuant to the representations filed by the petitioners and similarly situated candidates, the expert committee was set up and it has already submitted the report since 5th October 2018. Suitable action for consideration of the candidature of the petitioners in terms of the said report will be taken by the Commission and the state government. Accordingly, it is directed that the Commission shall open the report of the expert committee. This is the second report, second expert committee, and consider the candidature of the petitioners along with similarly situated candidates in terms of the said report. Then, my lords, at page 24, Odisha Public Service Commission passed an order, and my lords, I must confess this order suffered from non-application of mine. We rejected the claims of the petition of those petitioners without really going into the second expert committee at all. I will show all that, Your Lordship. I will show all of that. Yes, my lords. I'll show all of that. So, my lords, thereafter at page 26, they came in contempt. They came in contempt, and the contempt court granted me another opportunity to apply my mind and pass a reasoned order. We got away with it, my lords. At page 29, finally the order was passed, and this order was what was impugned before the single judge. Page 29. The relevant portion is the last paragraph of page 29. And whereas in the revisited merit list, only the petitioner Dr. Suman Tripathi of WPC OSC number this is found eligible, and the remaining 5 petitioners, namely Dr. Sanjay Panda, Dr. Krishna Nanda, Sabyasachi Panda, and Dr. Santosh Jaina and Dr. Anil Kumar Sahu, are not found eligible as they have secured less marks than the cutoff marks in terms of the expert committee report of 5/10/2018. Malats, what happened was, when a new expert committee came in, which revised the answer key, the answers of all the candidates changed. So the marks secured by all candidates changed.
Has to be.
That is exactly the point, Malats.
Somebody who's already appointed may go out. May be thrown out.
Your Lordships.
And somebody who was really thrown out may come in.
I'm grateful to Your Lordships. That is exactly what has happened in this case. Now, Your Lordships may kindly have page number 31. And this is the new select list. At page 33, serial number 118 becomes the last selected UR male category candidate. Serial number 118, Haripad Das. And now his marks have changed to 192.558. It has increased slightly. And in fact, my lords, everyone's marks have changed. Either some have increased, some have decreased. Your Lordships will notice that there are some grayed out names in that list. Grayed out names, they are persons who have become eligible under the new list, but their names were not there in the earlier list. So they have become meritorious, but they were not granted appointment because posts had already been filled up. I will just take your Lordships back to page 12 also. because there are some grayed out names over there also, and I'll explain the significance there. Page 12. The first select list. Well, the lordships have page 14. Page 14 also has some grayed out names. So the grayed out names in the first list have already got an appointment, but they actually did not find a place in the second list. My lords, that is what has happened. Now your lordships may kindly have page number 42. Your lordships may kindly have page number 42. There is a chart at page number 42, and this explains the situation of the present respondents. Serial number 1 is Dr. Sanjay Kumar Ponda. The cutoff mark as per the first expert committee is 189.558. He had secured 184.210. As both cases, he's out.
And in the revised, he secured even less.
In the revised, he has secured slightly more, Melons. From 184, he has gone up to 191. But the cutoff marks have also increased.
But claiming that those persons who have been already selected, they
Precisely, they are now claiming a negative equality. That since some people by mistake who are lower than me in marks have been selected, I have a right of appointment. Now, as the question of law that the learned single judge decides, the learned single judge at page 207 of the brief, internal page 35 of the judgment says that the OPSC did not have the jurisdiction to revise the cutoff mark.
What exercise it has to do in terms of the order of the court to set up an expert panel?
As the learned single judge did not appreciate the difference between a minimum qualifying mark and a cutoff mark. Minimum qualifying mark is like a pass mark.
That's true.
That cannot be changed.
Cutoff mark is depending upon the number of the seats or the number of the court. It is there.
I bowed on my. And it is a function of the answer key. Whatever marks have been secured by the last candidate, that is the cutoff mark. It is not a power of the OPSC to fix a cutoff mark. That is the issue before this honorable court.
What issue then?
That means, therefore, the finding of the single judge has to be set aside. The finding that
this cutoff marks cannot be fixed or something like that. Or
Yes.
The learned thing.
Where is the finding?
The judgment starts at page 173 of the brief. 171 of the brief, Your Lordship. The findings start at page 205, paragraph 44. The relevant is paragraph 45 and 46 at page 206. Paragraph 45, may I read, Malas? On a careful consideration of the cutoff mark fixed for the written examination, this court observed that initially the cutoff mark for UR male category was fixed at 189.558. However, the same was revised subsequently on the advice of the expert committee, and the same was refixed at 192.558. Since the petitioner had secured 192.002 marks after re-evaluation, and the same was found to be below the revised cutoff, that is 192.558, the name of the petitioner has not been recommended by the OPC to the government for such appointment. However, this court is indeed perplexed to observe as to how the OPC could recommend the names of Dr. Sripada Das and Dr. Debashish Sahu. Your Lordships will see they have secured less than 189.558, but I will explain that. They are part of the 4 persons who were recommended later on because people did not join. 46. On a query being put to the learned senior counsel appearing for the OPC by this court, learned senior counsel appearing for the OPC submitted the cutoff mark has been revised on the basis of the suggestion given by the expert committee set up by the OPSC. No further explanation is forthcoming from the side of the OPSC to justify the revision of the cutoff marks after conclusion of the entire recruitment process. In the aforesaid background, this court is of the considered view that the OPSC should not have revised the cutoff mark from 189.558 to 192.558. Further, this court feels that the OPSC, after re-evaluation of the petitioners and similarly placed other persons' answer scripts, should have applied the revised cutoff fixed earlier, and on such basis the case of the petitioners and similar other persons should have been assessed. Then they say that the rules of the game have been changed. When I'm changing the answer key, the cutoff marks automatically changes. I cannot change the answer key and apply the cutoff marks of the earlier select list. My lord.
May I please, can it be taken up tomorrow 10:30? 47. At 10:30, so. No, the entire submission made are not correct in facts. What is the direction made by the Honorable Single Judge and what is the direction made by the contempt court that has been not properly placed before Lordship. I will bring all those facts before Lordship. Only the facts.
What I must be very candid in this regard. What I must express by my
Yes, ma'am.
Yes, ma'am. The thing is that there was an order passed by this court relating to this answer keys, the questions. There must be an order in this past for sending up of the expert government.
No, madam.
That was done soon.
No order. And this Honorable Court.
And what this honorable court says that there was some discrepancy in the answer keys.
This Honorable Court directed the OPSC only those who have made representations to the OPSC, their answer key may be scrutinized by the OPSC in terms of the expert committee report. And accordingly, they evaluated the answer script of 6 candidates.